If I mutter and you hear too much, tell me to shut up.
Good morning, everybody. Welcome to September's Rotherham District Council's Planning Committee meeting. I am Councillor Brian Drayson, Chair of the committee. The committee is required to consider the applications that are before it today against national and local planning policies. Where these policies appear to conflict with each other, the members are required to use their individual knowledge and judgment to come to a decision for the benefit of the district as a whole. It should be noted that the Planning Committee is not a public meeting, but a meeting that the public may attend. Rotherham District Council has a public speaking scheme which allows members of the public and others to address the committee on a particular application. Full details of this scheme are available on the Rotherham District Council website. We are joined in the chamber this morning by the following officers: Gillian McInnes, Interim Head of Planning; Kirsty Cameron, Principal Solicitor Planning. On the outer table, we've got Sarah Shepherd, Development Management Team Leader. Then we've got, down that road, we've got space, which I'll come to in a moment. Then we've got Ruben Hayward, Planning Officer. Michael Vladanu, Planning Officer. We will later be joined by Simon Richard, a Conservation Consultation. Then we've got Edwin Cork, Principal Planning Officer. And then Rivi Kinsella from the Pevensey and Cuckmere Water Level Management Board. We've also got from Democratic Services Helping, I've got Julie Hollands to my left, the committee secretary, and Eleanor Drew is helping with our webcast. We have one councillor who will be speaking later. She's not a member of the committee online, Councillor Sue Burton. May I remind members in the chamber to make sure they turn their microphones on before speaking and that they speak clearly and directly into them, and then turn them off when they've finished. Neighbours, if you see someone's left it on, or if you see me and I've left mine on, please let me know. Members of the public, we keep trying to get it heard better at the back. Those speakers are on, but of course when we test it, it's not full of bodies, which might then soak up some of the sound. Members, please try and speak as close and as clearly to the microphones as possible, because although the webcast can be quite clear, it can sometimes fail to reach the back row of the public gallery. For those in the chamber this morning, there are no fire alarm tests scheduled for today, so in the event of an alarm, all persons in the chamber are asked to leave by the nearest fire exit and reassemble outside in the front car park. It's important that you remain there long enough to be accounted for, so that emergency services don't waste time looking for people who are not in the building. Can I also please ask everyone to make sure that their mobile phones are switched off or in silent mode. And now to the agenda. Item 1, do I have your authority to sign the minutes of the meeting of the Planning Committee held on the 18th of July as a correct record of the proceedings? Thank you. Thank you. Item 2, apologies for absence and substitutes. Julie.
Yes, so we have apologies from councillors Mrs Cook, Gordon and Mia, and Councillor John Bounds is standing in today as substitute for Councillor Gordon.
Thank you. Item 3, I'm not aware of any additional agenda items, but I should mention that there will be no agenda item 13 today. The planning performance report will be presented to the October meeting. Item number 4, withdrawn applications. Any withdrawn applications?
No, there's none.
Thank you. Item 5, disclosure of interests and dispensations. To receive any disclosures by members of disclosable pecuniary interests and other registrable or non-registrable interests in matters on the agenda, the nature of any such interest and details of any dispensations obtained. Also, if any members consider themselves to be predetermined on any matter, they should declare it and leave the chamber at the appropriate time. I will start the ball rolling on this one. In relation to agenda item 7, RR 2023-2540P, the architect's firm in the case is owned by my son and his husband, so I will therefore hand over the reins to Vice Chairman Stanger for that application and leave the chamber. Also, in relation to agenda item 9, my home backs on to Egerton Park. This is in no way a personal interest in any shape or form, and I'm totally unaffected by the application to put fencing around one of the courts. However, if I withheld that, people might think it was suspicious. I do intend staying for that discussion and taking part in it. Are there any others, please? Councillor Bayliss.
Yes, thank you. I'd also like to declare an interest in agenda item number 9, Egerton Park, as the local district council member for that area. I am predisposed to support the application. I'm not predetermined, but I am predisposed and would like to stay and speak in favour of that application, but I feel it's important, like yourself, to declare an interest.
Thank you. Councillor Gray and then Councillor Barnes. Councillor Gray.
Thank you, Chair. I would just like to say that in respect of item 7, I do know 2 families that live in that area. One of them, the couple, are members of the local Green Party. I've sought the advice of the monitoring officer, and she has said that she thinks neither of these 2 families are registrable interest, so I won't declare it again.
Yes, you see, but it's that information that if people found out that we hadn't told you, you'd be perhaps being accused of nefarious activity. Councillor John Barnes.
Chairman, I am the Vice Chairman of Egerton Parish Council, which has commented on one of these applications. However, I always, at the start of the meeting, say that I'm a substitute member of the Planning Committee and take no part in that agenda item.
Thank you, Councillor Barnes. One moment. Is that item 7?
No,
Sorry,
it's actually, they have not commented. Sorry, is it item 7?
Is it Burwash?
It's the Hurst Green item. We have recorded comments there as a parish council.
Thank you. Councillor Byrne.
No, it's not 11.
No?
No, it's item 7. It is item 7.
Thank you.
Sorry, I miscounted.
That's right. Councillor Byrne.
I don't know whether this is registrable or not, but for items 9 and 10, I'm a member of the Bexhill Town Council.
I don't think it's relevant, but if it is relevant, I should declare the same. Thank you. Any others? Right, thank you very much. Agenda item 6, which is the planning applications index. The final page of this report shows the applications being considered by the committee today. For each application, the officer will first present their report to the committee. Then, if it is subject to the public speaking scheme, any registered speakers will be invited to address the committee for up to 5 minutes on their previous written submission. Members may then ask questions of those speakers to clarify what has been said. Then non-committee members of the council will be invited to address the committee if there are any wishing to speak. Then members will ask questions of the officer before being invited to make any comments themselves and debating the merits of the proposal. The committee will then proceed to a vote. The members of the committee understand that planning matters can be very emotive, especially for those directly affected by the outcome. Nevertheless, I would like to ask everyone within the chamber to remain calm and courteous throughout the meeting. Thank you. We're now coming to agenda item 7. I redeclare my interest as being related to the architect in this application. So handing over to Vice Chairman, Councillor Jimmy Stanger. Thank you.
Hello, welcome everyone. I'm Councillor Jimmy Stanger, and we'll get on with the applications. Agenda item 7, application RR 2023-2540P, Burge Hill, land south of Hurst Green, outline erection of up to 7 dwellings, associated infrastructure, and all matters reserved except for access. Just re-declare that any members have any interest related to this application, please let me know now, either personal or pecuniary. No, that's fine. And we move on. The officer presenting the case today, Aisha Chamberlain. That's correct. Oh, sorry. Just press your mic on, thank you.
Good morning, this is Aisha Chamberlain. I was the case officer dealing with this application. And the application is an outline permission. Oh, sorry. And this application is an outline planning permission for 7 dwellings, 2-story. All reserve matters except for access. And the application site is an undeveloped field covering an area of 1.58 acre, located on the south side of Burke Hill within the Highfield National Landscape, designated as area of outstanding natural beauty. Although the site is outside the defined development boundary of Hurst Green Village, it joins to the development boundary on 3 sides, north, east, and west. And it is also included in the extended development boundary in the draft Hurst Green Parish Neighbourhood Plan, and is also allocated for up to 7 dwellings. But because the neighbourhood plan is in still consultation and draft, limited weight is given to it. And the site is bounded by trees, broad hedges. Trees along the east side benefit from TPO. Although the site is not in the development boundary, it is not isolated. It's still part of a rural settlement, and it is within the walking distance to the local services and facilities. And therefore, the site is considered to be in a sustainable location in terms of accessibility. There are no public right-of-way through the site, but there are 2 public right-of-way on the other side of Burke Hill through the woodlands. And there is limited visibility to the site from those, but mainly the site is obviously visible along the Burke Hill. The proposed access arrangement will involve opening up 4 new driveways to serve the proposed dwelling, and as part of this proposal, the hedgerow along the roadside will be removed and a new footpath 2 meters wide will be provided to improve the accessibility. The main local concerns from the locals are basically the site outside of a development boundary and harmful to the character and appearance of the Highfield National Landscape, increasing traffic flow and insufficient parking, harm to the protected trees, hedgerow habitats of local ecological interest, wildlife and protected species, increased surface runoff water, lack of affordable housing. The proposed, what you see on the screen are the These are the landscape views which are taken from the submitted landscape visual impact assessment. And one of the most controversial elements of this proposal is that the road hedge will be removed, and it is identified to have some merits, value. It has value. There is the report.
Sorry.
Oh, okay, sorry. Yeah. Okay. Yeah, the road hedgerow has habitat and value, and also it contributes to the landscape character of the High Weald national landscape. So that is one of the most controlled elements of the proposal, the removal of this hedgerow. But during the assessment of this application, we worked closely with the ecologists, and we consulted Natural England, and Nature England did not raise an objection. And it is with the submission of additional surveys and ecological information that the loss could be potentially mitigated by providing new hedgerows behind the footpath, and also with the appropriate landscaping and providing trees along the road to provide canopy connectivity, and habitat connection could be established for the protected trees, for the protected species. And in terms of affordable housing, we did also secure affordable housing in accordance with the policy, via Section 106. And in terms of the increased surface runoff water, the site is not in a Environment Agency flood zone and not known for high risk for surface water flooding. And we also have a condition for drainage strategy, so that could be also mitigated. It is accepted that the proposed development will have impact on the AONB. There will be some harm, especially the views along the Burke Hill, but the benefit from it outweighs its harm. And it's also should be noted that it is within a part of Burke Hill where there is a low density linear development pattern, and this development will be complete the linear development pattern, and with the appropriate landscaping, especially when the trees and hedges grow in 15 years, the impact will be mitigated.
We can have comments from the back, please. We must be silent in the public gallery. Thank you. Can you speak up?
Yeah. As I said, it is accepted that the proposed development will have impact on AINB, but the benefit from the additional housing will outweigh it in this case, because the council does not have 5 years housing supply, and there is a landscaping strategy which could potentially mitigate the harm once the trees and hedgerows grow along the Burke Hill. So that will minimize the impact on the AINB. And besides, the proposed development will complete the linear development pattern on this part of the Burke Hill. And we also secured quite a number of, or we also put a lot of ecology conditions. And there is a biodiversity Section 106 agreement which will include the field to the south of the application site. It is within the ownership of the applicant, so that could mitigate some of the harm to the biodiversity. Thank you.
Thank you very much. Thank you. Just to clarify, the recommendation from officers is to resolve grant outline planning permission delegated subject to conditions and completion of a Section 106 legal agreement in relation to affordable housing provision and biodiversity net gain. Just to clarify, that's the recommendation before the committee. Now we'll hear from the parish representative, which is Ned. Let me get his name. Ned Packingham. Councillor Ned Packingham, please take the seat. Thank you. Yeah, take your seat, get yourself together. When you start, it'll be 5 minutes and we'll be timing. Whenever you're ready to go, yeah, give us a thumbs up and then you're ready to go, yeah?
Okay. Good morning, everyone. My name is Ned Packenham. I hope everyone can hear me. Forgive me, I haven't actually written a speech. I'm just going to work from notes. And my esteemed colleague, Corinne, who is the head of the Residents' Committee, is going to make the main substantive arguments. But I just want to mention a few points. The first is about our housing target. So we have in Hurst Green a housing target of 75 homes. We are delivering 74 homes. We are on track to meet our housing target without this application. So I was very surprised to see that that was not reflected in the planning officer's report. There will be a few windfall homes as well, so we'll probably end up at 77, 78. Now, if we end up with another target in 2 or 3 years' time, we can cross that bridge when we come to it. But at the moment, we are on track and we don't need these extra houses. The second point that dismayed me about the planning officer's report was the reference to the neighbourhood plan. Now, we have no neighbourhood plan in Hurst Green. We are a substantially 7 out of 9 new set of parish councillors. And one of the reasons why there's been a massive switch in the composition of the parish council is that most of us were very unhappy with the draft neighbourhood plan, which went out to consultation a couple of years ago and only had 17 respondents. 17 people filled in the form out of 1,400 people in the village. So it's a question of democratic legitimacy. Only 5 people commented positively on the prospect of Burr Hill being turned into housing development. So that's 5 out of 1,400 people. We don't feel there is a legitimate democratic basis to go forward with our draft neighbourhood plan, so we have abandoned that and we will pick it up next year when the dust has settled. But at the moment, it should not be given any weight that there was, at least temporarily, a plan to include this field in our neighbourhood plan. All of us have voted not to include it, even if it's given planning permission. The third point I wish to raise is the question of sustainability. Now, the planning officer said this was a sustainable site. We only have one proper shop in the village, and it's called Eggs to Apples. It's an upmarket farm shop. It's a 25-minute walk from Cook's Field. Now, if you're carrying food, you've got two bags of shopping, you are not going to walk to that shop. You are going to get in your car. So we are against the very principle of sustainability in this site. It's a car destination if houses are built there. And I know all of you want to encourage central locations in villages so that people can walk to the remaining shops. Now, my final point is just about the inherent beauty of the site. It is a lovely field. It is the climax of the main walk that we villagers take in the village, which is because we are blighted by very, very heavy traffic, principally along the A21. The only place that people really go walking in the village, the only safe place, is along Burr Hill. And the climax of that walk is indeed the top of the hill, where Cook's Field is. And it's a lovely moment when the houses peter out and you can survey the valley, and you can see for miles around. And we are at risk of losing that. It's the nicest thing in terms of the landscape in the village. Of course, there are other fields around Hurst Green, but when a lorry is passing you every 1.5 seconds, you don't really get to stop and stare and enjoy it. So this is a lovely spot, and we should be very, very loath to lose it. It's also very prominent because it's set high up in the landscape. So it can be seen from miles around. It can be seen from the other raised area in the village, which is called Silver Hill. And of course, the developers have hired people to minimize its landscape views. That's what they do. We should expect that. But I don't think that the visuals that they
15 seconds.
I don't think the visuals that they have produced are a fair representation of its prominence within the local landscape. So those are my points. Thanks very much for listening to me.
No clapping for the public gallery, please. Thank you. This is a meeting in public and not a public meeting. Any questions for the speaker? Any questions from the speaker, or based on what was said?
Yes, thank you. I appreciate the clarification around the neighbourhood plan, and that was certainly something I had looked at when reading through the papers, that actually it had been included in the Hurst Green plan and has now been stopped. But from my perspective, and I'd appreciate an answer on this, as you drove, and we've obviously made a site visit here on Tuesday, as you drive along that particular road, you've got it's a ribbon development of properties, and there is a private field between two properties where obviously this development's going to take place. Why is it so important that that ribbon development doesn't carry on across that private field? The public don't have access to it. So why is it important that, that people don't get the benefit of living in what is a beautiful part of the countryside?
Well, it's not just enjoyed by the immediate neighbours around the field. It's enjoyed by everyone who walks up and down Burr Hill. Dozens of people make that walk every day, and most of them are coming from the historic centre of the village, not the 20th century extension, which is Burr Hill. So it's a site enjoyed by everyone, and it's a very important stopping point looking across the landscape. Of course, there's been casual development around it, but this would be the nail in the coffin as far as the rural quality of the lane would go.
Thank you very much. Yeah. Any further questions for the speaker? Mr. Barnes, Councillor Barnes.
Yes, I ought to preface my remark by saying I was the county councillor for this area for 21 years, so I do happen to know it quite well. It's what Councillor Bayliss has just said about ribbon development isn't strictly true. And I'd ask you a question to try and bring this out. This is on the boundary between...
Councillor Barnes, is not a question for the officers?
Yeah, could you comment on the south side of the road as opposed to the north side, and on the fact that this is on the boundary between two parishes?
Well, yes, we are petering out in terms of Hurst Green at that point. We're very, very close to the border with Etchingham. The houses on the north side are much less visible from other parts of the landscape because they are almost submerged in views of the Burr Hill woods themselves. So it is more sensitive because it's visible from the south. I'm not quite sure what you mean, John, there. So,
Was Sorry. Yeah, what was the question you were getting at? Sorry, Councillor Barnes.
I mean, the amount of development on the south side of Burr Hill is less. The majority of the houses are on the north, and they are mitigated by the woods behind them, so they are less visible. It's the landscape view it's the views across the landscape that make this site especially sensitive, that wouldn't apply if the field was on the north side of Burr Lane.
Okay, thank you, Councillor. Councillor Groner.
Hi there. There was some mention of the development boundary being on three sides.
Well,
do you know historically why that came to be? Because it's obviously been left out of the development boundary for a reason.
Councillor Groner, I think a question for the officers, I'm being told, about boundaries.
I think that's a historical knowledge of the parish seems very
remember,
deep with this
The
gentleman.
development boundaries will be down from the officers.
I do know that for at least 50 years this has been refused as a site for development. And the same arguments they're still there, which is that it's a sensitive site that would effectively suburbanise Burr Lane. And that's not what we want. We've never included it in our development.
So, thank you very much. Any other questions for the speaker, but not officer related? No? Thank you very much, Councillor. Next up, we have Corinne Stewart, the Burge Hill Community Group. Get comfortable in the seat and you'll have 5 minutes when you're ready. Hello, Corinne. How are you? All right?
I'm very well, and good morning, councillors.
When you're ready to go, let us know and we'll start the timer.
My name is Corinne Stewart, and I speak for the Burr Hill Community Group, representing residents of Burr Hill, Hurst Green and Etchingham. As evidenced by more than 100 objections, we are horrified by the damage this application will cause to the national landscape, the needless destruction of an ancient hedgerow, loss of biodiversity, including endangered species protected by law, and the negative impact it will have on the people of Hurst Green. We are heartened by the vision of the council in the new local plan for being green to the core and living well locally. However, neither is satisfied if access is granted to bulldoze Cooksfield. Cooksfield is given the highest status of protection as part of the High Weald National Landscape. Development on Cooksfield does not further the purpose for which the national landscape of the High Weald was designated. Even slight harm to Cooksfield is incompatible with the conservation and enhancement purposes of the designation. Allowing development of this site will cause a significant visual intrusion, with the houses seen right across the Rother Valley and visible for miles around. The sensitivity of Cooksfield is best summarised in the 2019 AECOM Hurst Green Neighbourhood Development Plan Site Options Assessment, which classified the field as red, not to be built on. It said, the site is judged to be of high landscape sensitivity to change because of its location on the edge of the valley to the east, its enclosure by trees, and its view to the east, which reflect the special qualities of the AONB identified in the AONB Management Plan. It is also within viewpoint 2 of the core strategy Market Towns and Villages Landscape Assessment, where it concludes there is a low ability to accommodate change. The previous council chose to ignore this, and you've heard from Ned Pakenham representing the present parish council about their objection. This application, if granted, will be ecologically highly damaging, resulting in the destruction of a biodiversity-rich pasture and have a devastating impact on endangered and priority species. The applicant admits there is no net biodiversity gain. In fact, the removal of a 180-metre long hedgerow along the southern boundary in 2019 without planning permission means biodiversity loss will be further compounded. We are alarmed at their proposal to remove the remaining ancient hedgerow, part of the historic ancient routeway that is the character of Burr Hill. The plan for oak saplings to replace this important hedge is absurd. Dormouse habitat is not in the canopy of oak trees that take 40 years to produce acorns and another 150 to 300 years to reach maturity. The pavement replacing the hedge cannot be connected to the existing footpath on Burr Hill as required by highways without compulsory purchasing neighbours' front gardens. Burr Hill is constricted at both ends with a dangerous right turn into the lane from Hurst Green. My house is at the narrowest part at only 3.5 metres wide, and traffic has to pull onto my drive for two vehicles to pass each other. A car encountering a lorry means that one of them has to back up along the lane. And the elderly residents of Burwood House are very concerned that the increased traffic from 7 houses and corresponding cars, delivery vans to each house, plus increased parking, will lead to ambulances and fire engines unable to get through, especially when accidents occur on the A21 and A265, as all traffic, including heavy lorries, is diverted along this lane. Burr Hill is the only tranquil lane in a village blighted by the A21. It is used by walkers, cyclists, runners and wheelchair users who enjoy the distant views over the high wheel to the south. And this will be lost to the 1,500 people in Hurst Green forever, and also that 7 houses can be sold with a view. Neighbours, most particularly the Laurels, will be overlooked. Contrary to the applicant's submission, houses facing the field are not 3 metres higher than the field. The field itself is wedge-shaped and 1.5 metres higher than the road at the narrowest part of the lane. And they seek to mislead when they claim that the water runoff will run down the southern side of the field under the busy A265 and into a stream. Councillors, there is no gully under the road and there is no stream. The applicant has left a wide access route to the southern part of the field. At the public meeting in Hurst Green in February, they refused to rule out further housing on this part of the field, and their site layout appears to support this intention. The retained route also gives them access to further fields beyond. Finally, the proposed development is in breach of many planning policies as outlined in our submission, and the planning officer ignores the Monk Hill Court of Appeal decision, opening this council to legal challenge. We ask councillors to reject this application. Thank you.
Thank you very much, Corinne. Any questions for the speaker, please, related to what the speaker's just said? Many thanks. Councillor Mary Barnes.
Thank you. Hello, Corinne.
Hello.
Can you go into a bit more detail about what you said about the wedge-shaped nature of the field and how much higher it is at one side?
Yes, so at the narrowest part of the lane, it is 1.5 metres above the road. That's because it's an ancient routeway. And so over hundreds of years, the road has gone down. It's actually a wedge-shaped. So the pictures of the applicant's pictures are totally misleading. It does not give you an idea of exactly the fact that it is higher and then lower. The highest end is next to the TPOs as well. So given that it will have to have 15 metres from those TPOs for the development to then begin, it means that the houses are going to be overlooked, especially with the Laurels. And I believe that they have actually sent in a letter to that effect to the planning officer.
Thank you. Does that answer your question, Councillor Barnes?
Yes, it does, but I have then the feeling that the houses themselves are going to be very high. Is that right?
They are going to be high, and the LVIA by the well, quite frankly, was very surprising because it said that the houses bounding the field...
Just to clarify, this is outlined, so it's not interpreted yet, is it? No. Outline at present, so I think we're deciding outline except for access.
But Chairman, isn't there a standard height for
Chairman, if the case officer could clarify whether it is specified that they're going to be 2-storey in the description, which I don't believe it is, or whether it is outlined for up to 7 units for the design to be determined at a later date.
I mean, the design and access statement basically gives some sort of induction of the mass of the buildings.
But can I clarify that is...
No, it is, yeah, it just gives an indication.
It's illustrative.
Illustrative indication that 2-storey, but
So Chair,
It's likely to be.
apologies for the confusion, but just to be clear, this is an outline application where the only matter for your determination is whether up to, not 7, but up to 7 houses can be accommodated on this site. The issues of height, mass, width, design will all be for a later determination. So the future applications could be anywhere between 1 through to 7 units, because this is an outline application to address the principle of development.
Thank you, Gillian. Hang on 1 minute. So there's any more questions for the speaker before we'll move to the officer later for any questions for officers? Any questions? No, thank you, Corinne.
Thank you.
Thank you very much. Next up is Becky Brown, the agent. Hello, Becky. Get comfortable and let me know when you're ready.
Thank you, Chair. Good morning, Chair, Vice Chair and members. Thank you for allowing me the time to speak in support of this application on behalf of the applicant. We thank your officers for working proactively with us and for their comprehensive report, which balances all material considerations and concludes that you should resolve to grant outline permission, subject, of course, to conditions in the Section 106. This application represents the culmination of many years of promoting and discussing this site locally. The landowners started promoting the site known as Cook's Field as far back as 2003, when it became clear that Hurst Green would need to provide additional housing to meet its own needs and those of the district. This site on the southern side of Burhill appeared logical as it represents a gap in an otherwise built-up frontage. It's a typical infill site. There are dwellings, as you've seen, on both sides and to the north. Representations have been made to the neighbourhood plan at every stage, which has culminated in this site being identified as suitable for residential development in the most recent version of the plan, the Reg 14 pre-submission version, which, as we've heard, was consulted upon in summer 2022. The site-specific policy identifies a site capacity of up to 7 dwellings. Compared to the other 3 site allocations, Cook's Field was considered more favourably by those who responded to the consultation. The District Council didn't raise any concern with the principle of allocating this site. They commented that the character and pattern of the built form is directly lining Burhill, i.e. frontage development, and this current scheme therefore proposes a linear form of development restricted to the frontage of the site, with dwellings set back from the road and at a lower level to respond to the landscape context, because they're set back into the site. With regards to the core strategy's 75 home requirement for Hurst Green, only 46 homes have actually been granted permission. They're at Foundry Close and London Road North. Although another 28 are proposed for the London Road South site, this application was submitted back in June 22, and it still remains undetermined, suggesting there may be problems with that application. As referred to in your officer's report, this site has also been subject to pre-application discussions with both the district and county councils. The landowners have been submitting this site through the land promotion process whenever an opportunity has arisen. As the neighbourhood plan process is now stalled, they felt they had no option but to proceed with a well-considered application supported by a comprehensive suite of site-specific reports written by experts in their field. The indicative or illustrative layout has been informed by a detailed study of local settlement patterns and the prevailing vernacular, and also responds to the specific characteristics of the site. It shows that 7 dwellings could be located and orientated to respect the existing line of development either side, and there is sufficient space to provide generous living accommodation, car parking, garage space and outdoor amenity space. It's just showing one way of how up to 7 dwellings could be accommodated on the site. As we've heard recently, it's an outline application for up to 7. There is a mixture of large 2 and 2.5 storey traditionally designed detached houses in the village, as well as some bungalows interspersed with modern architectural design, but the prevailing character of the locality is reflected in the scheme, which indicates 2-storey homes using a palette of vernacular materials. Furthermore, the application will improve pedestrian accessibility in this part of Hurst Green through the provision of a new section of footway immediately adjoining the southern side of Burr Hill.
1 minute remaining.
This will facilitate walking to the local facilities and amenities in this local service village, not only by the future residents of this development, but also existing residents. As well as providing much-needed open market housing, the scheme will also deliver affordable housing, and this will be secured, as we've heard from the planning officer, through the Section 106. Although not subject to the statutory 10% BNG, as the application was submitted back in November last year, this proposal will result in significant on-site hedgerow BNG of 34.12%. This is because as much of the existing hedgerows as possible are to be retained and many more are to be planted. A large number of trees will also be planted within the site to include heavy standard oaks on either side of the accesses along the frontage. The applicant is also committed to providing additional habitat BNG off-site, which again will be secured in the normal way through Section 106. The application provides an opportunity...
Thank you. Sorry, that's 5 minutes. Thank you very much. Any questions for the speaker, please, related to what she said? Any questions? Councillor Groner.
Hi there.
Hi there.
I'm just looking through the office's report here, and it says the erection of 6 4 to 6 bedroom dwellings. Is that correct? Is that what you're thinking?
The application is an outline application for up to 7, so it's between...
The summary of the pre-app response for the erection of 4 to 6 bedroom dwellings. That's what I'm confused.
I think that refers to the pre-app.
Pre-app.
Well, is that going to stay in the outline, or was that...
No, the outline will be for a maximum of 7 dwellings, up to.
Yeah, but it's 4 to 6 bedroom that sort of... We were discussing the size and the mass of them before, and then it's outline.
Chairman, if I can...
But it does say in here, 4 to 6.
Yeah, if I can explain that in advance of applications being made, regularly developers and house builders will come to us to ask for views on a range of different schemes. And that is a pre-application inquiry.
Yeah.
So they have undertaken that pre-application inquiry, but that is only background to this application. It is not related to the detail of this application.
Sure.
This application is only for the principle of up to, and I stress up to 7 dwellings, and the access arrangements. So that is what is in front of members, not what might have been discussed before or what might happen in the future. It is only the principle of a red line round this piece of land and the access arrangements that is before you, and the principle of having residential housing or a house on this site.
Thank you, Gilly. Any further questions from the committee? Thank you very much. Please return to your seat. Thank you. Just want to clarify if any of the ward members wish to speak on this application.
I'd like to speak as the county councillor.
Thank you, Councillor Clover Green, yeah. Yeah, and unfortunately, I think your position on the committee supersedes your ward position. So.
And I have spoken to Linda, the monitoring officer, and I have told her that I have been very, very careful indeed to avoid any contact with anyone who would in any way sway my judgment on this.
Yeah, we're not saying that you predetermined, just saying you can speak as a planning committee member on the application, but not as the ward representative.
Chairman, to be clear, and I'll maybe pass over to Kirsty, all members of the committee must make decisions based on the whole of the district. You know, it is all about Rother district and the whole area. So regardless of whether you are a ward member for that area, your duty on a planning committee is to determine applications as part of the committee in terms of the wider Rother. A member who wants to speak as a ward member, that is a different role, and then they would be outside the decision-making forum. Thanks, Chairman. I don't know, Kirsty, if you want to comment.
So I think that was quite clear. You can't jump, but you're sitting making a decision on behalf of the council as LPA, and then it's a different role in terms of your capacity as a ward councillor. So obviously you can't speak as a ward councillor. You can contribute as a member of the committee, but obviously and make a decision. I think that's quite clear. I think that's distinct to the discussion that you had with the monitoring officer in terms of predetermination and bias.
Yes, but if I may refer, Gillian, to the conversation that we had on this, during the course of the site inspections, is that there may be things that I can add as a ward councillor that maybe other people may not know. But I think all the council has had, all the planning committee has had exactly the same amount of information. We have all received information from the group. We have all read the report. I can't think that I could in any way display any bias or anything that is any different to any other member of the committee speaking on this. So I don't understand.
It's just procedural. So obviously there is a slot within the procedure rules in terms of when we ask the ward councillor to speak to the planning committee. You can contribute as a member of the committee, and your experience of the ward may contribute to that discussion, but obviously you don't have the opportunity to sit back as a member of the planning committee and speak as a ward member as you would if you were not a member of the planning committee. So you say your experience as a ward in the ward and of the area, and other councillors may have knowledge and experience of the area that they want to contribute in the discussion, in the general debate, but in terms of you sitting back and speaking as a ward councillor, you're here as a member of the planning committee. Not been done previously.
Chair, it's only a matter of when you do the speaking, that this slot is for a ward councillor. In the order of events of the committee, it doesn't mean that you don't speak.
In that case, I think we should let Councillor Kirby-Green speak.
She will be speaking.
And then, but obviously I have got things to say. I do not want to forego my right to vote.
My understanding is that you still have the right to talk, but it will be in a general debate as a planning committee member. You can still say, obviously in an open-minded way, speak on the debate, but you can't speak in the ward councillor position. That's what I've been informed.
Right, okay.
I'll allow Councillor Kirby-Green, she can talk as a relevant ward neighbour member, but there will be no, because Councillor Colleen and yourself, you're here as a planning committee member.
With due respect, Councillor Colleen is not a member of the planning committee.
I just want to apologise to the public so we can get this cleared up. To apologise, bear with us. Councillor Kirby-Green, if we can have you next, please.
Thank you. Good morning. Sorry I can't be with you, but I had a prior commitment with my son. As I've mentioned, I'm the County Councillor for Hurst Green. I just want to make a few points in response to the officer report. The first of which, this is not a sustainable site. It is all very well to say that amenities are 20 minutes away. However, the only amenities the new residents of these houses are likely to want to access are Exeter Apples and Planters, both of which are on the A21, and a 25-minute or 35-minute walk. It is not realistic to suggest that people will take an hour to walk to and from either of these. From experience, walking along the A21 is not at all pleasant, with fast-moving lorries passing you, and even less so if you are carrying bags of shopping. Likewise, the school sits further down the A21, not an attractive prospect to walk young children along the A265 and then the A21. The idea of walking to Etchingham Station may be attractive on a sunny spring morning, but walking back a steep hill in the winter less so, and I am not aware of any current residents living at that end of Burr Hill that do this. Therefore, people in these houses are going to be reliant on their cars. In addition, there will be deliveries, window cleaners, gardeners, cleaners, friends, family, personal trainers, all driving to these houses. Given that the only other roads in the village are the A21 and the A265, Burr Hill at the moment is the only lane people wish to walk their dog or generally go for a stroll on. It is where the residents of the nearby sheltered housing can walk. Secondly, and I know Ned covered this, let's be clear, there is no neighbourhood plan. It is defunct and has no democratic legitimacy. The parish council has communicated this to Rother. So I'm very surprised to read the report suggesting that it is due to reach Regulation 16 this autumn. This is simply incorrect. Thirdly, I would like to draw your attention to the county landscape architect. Whilst the report suggests that there is no objection, this is subject to a number of conditions, one of which being that the field to the south of the site is retained as a flower meadow. This is a critical condition should this application be approved, but I cannot see it listed anywhere in the report. So on that basis, one can assume that the East Sussex County Council landscape architect would not support the scheme. There is also a comment that the loss of the hedge and the proposed footpath would have an impact on the character of the historic routeway, which are key components of the Highwood National Landscape as set out in the newly adopted management plan. That does not sound like conserving and enhancing the landscape as required in the NPPF. Interestingly, in my conversation with the highways officer, he told me that he didn't think for 1 minute that RDC would allow the hedge to be removed. Most importantly, this is a visually intrusive site which can be seen from across the valley. We are custodians of this national landscape and have a responsibility not to damage it for future generations. The NPPF quite clearly states the requirement to conserve and enhance. This proposed development does neither. The Monkhill judgment would not have been taken into account, which quite clearly states that the tilted balance does not apply in protected landscapes. Finally, there are two developments at various stages along the A21 in the heart of the village. Another two have been completed. Hurst Green has met its required housing numbers. It does not need 6-bedroomed homes in a green field. There are many planning reasons to reject this application, which have been listed by the Burr Hill Residents Group, and I would urge members to refuse this application. Thank you.
Thank you, Councillor. Councillor Bayliss, how can I help?
Yes, thank you. Can I just clarify with Councillor Kirby Green about the shops, the shopping point that she raised?
Sorry, I don't think questions. Huh? So no questions between the members, unfortunately. Thank you. You can mention it in the general discussions. The information I'm being. Yeah, Eleanor Kirby Green is not the ward member, and she's only a neighbouring ward member. She's speaking on behalf of
But she made a statement in her presentation to us, which I just wanted to check, because she said the nearest shop was Planters on the A21, but I'm sure when we go down to the site.
I didn't say that. I said the only two amenities that the new residents are likely to want to use are the Eggs to Apples and Planters.
Thank you very much.
Yeah.
Thank you.
Okay, that's what I said. Thank you.
We'll clarify that later
on.
I
wanted clarified. Thank you.
And we're going for question time for the officers now. So any questions for the officers, please? Councillor Mary Barnes and Councillor Ganley.
Yes, I wonder if the officer could clarify the bit about the 106, because I wasn't clear from that if it was intended that there should be two of the houses should have been affordable. Oh, I'm so sorry, very wrong. Everything's going wrong today. But can she clearly tell us what the statement about the 106 is?
Can you clarify that question, please, Mrs. Barnes?
Yes, I can't turn it up right at this moment, but there is a point about 106 being smaller houses, or for payment of 106 payments in lieu of the fact that these are all open market houses. What is the actual definition of that? Of that?
Press the button,
Page
please.
8.
Page 8. Thank you very much.
Paragraph 8. Paragraph 8, 11.2. 2 of the proposed dwellings would be allocated for affordable housing and
Chairman, yes.
Let the officer speak first. Okay. Yeah, officer speak first. Thank you.
Paragraph 8.11.2 in the report. 2 of the proposed dwellings would be allocated for affordable housing, and 80% of the remaining 1 dwelling would be payment in lieu contribution.
And can I just clarify, that's if there are 7 houses, it will be 2 and 80%. Otherwise, it will be prorated in the legal agreement. It will be written as a formula. So that's just to make sure that we get the appropriate level of affordable housing, depending on the number of units that comes in as the detailed matters.
Thank you, Gillian. Councillor Ganley.
Question, Mr. Chairman. Thank you very much. The interim planning manager said that the only thing we have to do at this committee meeting is to decide whether it can accommodate up to 7 dwellings. Those are your words. I would suggest that we also have to decide on the principle of development, number 1. And number 2, the suitability and sustainability of the site's location, as stated in the summary. So it's not just whether it can physically accommodate up to 7 dwellings, it is those other points as well that have to be considered. I'm sure you agree.
Head of planning.
I do agree.
Thank you.
I mean, it is that what you're looking at is whether the principle of this piece of land for up to 7 dwellings and the accesses is acceptable, with the balance of issues, including the council's lack of housing land supply, for example, and also the issues of biodiversity and quality of the landscape, and that is all what's contained in the committee report, Chairman.
Chairman, if I may, a very quick one. Reference was made by one of the speakers about water running off through a gully into a stream, and that apparently no gully and no stream exist. But I actually can't find any reference in the report about a gully and a stream, although I'm only looking at the, the water bit.
We don't have the drainage details because this is outline application, but we have a condition for further details.
The officer said this is outline and it will be dealt with conditions, the water management.
Yeah, yes. So I can forget. Okay, I can forget. Yeah, good. Okay, thank you. That's it.
Just so, Councillor John Barnes, then Councillor Bayliss.
So, as usual, we are handicapped because nobody from Highways chooses to be present. But I have to say, I'm worried about the impact of a 2-metre footpath which links at neither end to any existing footpath, which will narrow the road unless somehow we remove the hedge. Can we know what the measured width of the road is along there? Because I drive it regularly. And
I'll ask the officers for you.
It's not a road where 2 cars can pass.
The width of the road.
places.
The proposal will involve removal of hedges, but it will be within the site boundary, the footpath.
Within the site boundary, and the highways have an
And it
objective.
will also...
Within the site boundary, right?
Yeah.
That's helpful.
Thank you. Councillor Bayliss.
Yes, just to clarify, I mean, I've just checked where Eggs and Apples is and Planters on the A21. Yeah. But in fact, when we drove to the site on Tuesday, as we turned into Station Road at Hurst Green, there was a small local shop which was open, and there was people coming in and out, which is considerably closer than Eggs and Apples to the site. So I just wanted to clarify that. Is there any possibility about if we are granting outline planning permission that we talk about, or we restrict the height of any properties that's built on that particular site? So, for example, could we say that it would be, say, 7 bungalows as opposed to 7? No. Can we make that restriction?
Chair, I would strongly advise against that, because you want to, if you grant outline for up to 7, you want to have the ability to ensure that the details of the design are in keeping with the wider, residential layout of development in the area. And I think to limit yourself now, when a detailed plan comes in, when reserve matters application comes in, we can look at what the impact of that development is on the wider landscape.
Thank you. Councillor Byrne.
Thank you, Chair. Thank you, Chair. Just wanted a bit of clarification on point 2.4. Exactly what is the status of the draft Hurst Green Parish Neighbourhood Plan? We're hearing A, it's at stage 14, and B, it's been totally scrapped. I think it's interesting to know exactly what the status currently is.
It's a dead panel.
Chairman, I think the answer is we probably don't know, and there's no reason. We've got we had the speaker from the parish referring to it and saying that it was no longer going to be pursued. I would take that as it's no longer going to be pursued. What I would say was it was given very limited weight in the assessment of this application, and that the development plan, and more importantly in this case, the National Planning Policy Framework, were the key policies under which this was assessed.
So really 2.4 is we can almost strike that out. Is that true?
Chairman, from what has been said by the representative of the parish.
Thank you.
Thank you. Councillor John Barnes.
Yes, I want to get clear. Maybe this may be done better in debate, but I will abide by the ruling of the interim chief planning officer. I want to clarify the Monkill judgment, which said, in effect, that the tilted balance did not apply in this instance. We're talking here about a very specific clause in the MPPF, which is 11D. It has 2 separate clauses, one of which is if great harm is done to the AMB, then that means you can't apply the balance at all. If the harm is held to be limited, then obviously you strike a balance between the 2. It's the 11B little 2 that I think is being adhered to by the officers. And it seems to me we do need to be clear that that is a balance, not a tilted balance.
Yeah, I've just got Kirsty, our solicitor, is ready, and she will answer your question, Councillor Barnes.
As you know, the Monkill judgment set out the approach to interpreting paragraph 11D of the NPPF in cases where in the AONB. So where you're determining an application for housing in the AONB, you initially consider whether the tilted balance was triggered, and that is triggered where there's not an up-to-date housing, not an up-to-date local plan, or there is no relevant development plan policies. This isn't major development, so those principles don't apply. You then would consider what, if any, harm would be caused to the AONB, and then how much weight should be given to that harm, bearing in mind paragraph 178 of the NPPF, which talks, as you say, in terms of giving great weight to conserving and enhancing the AONB. And then you assess what benefits of the proposal there are and the weight to be attached to those benefits. Where you're looking at applications that are not major applications in the AONB, so non-major, it's a flat balance. So you consider whether the countervailing benefits outweigh the harm to the AONB, or does the AONB harm provide a clear reason for refusal? So that disapplies the tilted balance, and that's paragraph 11D2. So paragraph 11D states, where there are no relevant development plan policies, or the policies which are most important for determining the application are out of date, and then it's granting permission unless. One is the application of policies in this framework that protect areas or assets of particular importance, provides a clear reason for refusing the development proposed, or B, little 2, any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole. So only if the AONB doesn't provide a clear reason for refusal, you then apply the tilted balance and ask whether the benefits of the proposal are significantly and demonstrably outweighed by the impacts. And that's, I hope that explains Monkhill. So it's that counterbalance, but there's a distinction between major development and non-major development in the AONB.
Thank you, Kirsty. Councillor Groner.
Just to clarify further on that, are we looking at housing supply figures for the whole of Rother District Council or in the local?
Yeah, I was just about to clarify that before we get to debate. Obviously, we spoke earlier about Hurst Green's housing targets, but as a committee, we look at the whole district target and we don't look at individual areas. So. Councillor Bayliss, then Councillor Creasy.
Can I just clarify the point that was raised about the number of houses? So, to the planning officer, we've talked about, or people have spoken earlier about that the target in Hurst Green has been met. But then we had another speaker the agent, who talked about some of the applications haven't been decided yet. So what's the current position on that, please?
Yeah, I spoke to Head of Planning earlier briefly, and we decide on the whole district. We don't decide on the Hurst Green. But you want to ask about the Hurst Green specifically, yeah? Ask the officer.
Yes, I can answer that one. There are some applications that have been granted, and there are others that have been, the resolution is to grant, but the legal agreement hasn't yet been signed, so there is no permission on one of the sites. So at the moment, the lower figure that you were given for 40-something is the ones that have been granted permission. So no, they haven't actually met their full target yet.
Councillor, sorry, can we have no noise from the gallery, please? We cannot have any speech from, otherwise you'd have to be quiet in the gallery. I'd have to ask you to leave, sorry. Thank you. We have to have, it's a meeting in public and not a public meeting.
Chairman, just to clarify, Sir Shepherd has just said that there is planning applications that have been granted and also resolutions to grant, but we haven't actually issued the decision on them. But regardless of that, the specific number of units in this settlement is only part of the wider picture, and you as a committee must make decisions based on the whole of Rother. And I am sure members are aware that we are significantly below the requirement for delivery of housing within the borough, and that is an important material consideration for you in your decision making.
Thank you, Gillian. So we just have, so we've got Cheryl, Councillor Creaser, thank you.
So the oh, I'll have this one then. I'll have that one. So the situation I'm thinking of is that because their local plan for that area is defunct, then they have to, have what they've got. If you have another part of the district that has a functioning local plan, which is formed on what we do as a district plan, or we call it the local plan here in Rother, which does that the housing need overall, if you've already got a housing plan and you've got promises to do certain things, is that overridden?
I will ask Head of Plan.
Go on.
The plan being referred to is a neighbourhood plan. The district plan is a local plan, and both of them make up what is referred to as the development plan for the area. The requirements in legislation is that every decision maker's first point of consideration is the development plan, unless it's out of date, and then you look at the NPPF. In the case here, there isn't a made local plan. There isn't an, I'm doing it as well. There isn't a made or adopted neighbourhood plan. So the only part of the development plan available is the one that covers the district, or the parts of it that cover the district.
Can I just...
And it's very out of date, so therefore that takes you to having to consider in great detail the policies of the NPPF.
So the two thoughts that have gone in my mind. Hang on.
Sorry, one at a time, please, Cheryl.
The thoughts, I mean, I know what you've just said already, but what I was concerned about is to get clarification of what's going on here, because there are other places in the district that do have a current plan.
A neighbourhood plan.
A neighbourhood plan, which is then, obviously, it is informed by the local plan that we have produced here, Rother, and I'm part of that group that's actually done that. So I understand that. Hang on a minute, don't interrupt me, please. So the thing of it is I want to make sure that I'm getting this right, because I've obviously been involved in it. Plus the fact is, it sounds as if the people of that area need to get themselves sorted out and get a plan in place. Thank you.
Any part of the development plan that is up to date and will carry the most weight is the first point of determination. What I would say, and it's a general point, not necessarily for this application, is that you can have an up-to-date local plan and you can have an up-to-date neighbourhood plan, but if a site comes forward that is considered to be acceptable for other reasons, it doesn't mean that the automatic answer is no. But I think that's a broader point that isn't really relevant in this situation.
No.
Thank you.
Yeah, okay.
There we are. So, Councillor...
Well, I'll have a go, Chairman, but I must say, poor old Hurst Green. Am I allowed to make a statement which says that with 3 developments going on along the A21, life is absolutely untenable for them?
So are we finished officers' questions now, are we? And we're moving on to...
Can I just sort of say, so what, can I just, final clarification. So what we are in fact saying is that as a result of the fact that we don't have a neighbourhood plan, any spare bit of land that Hurst Green has is now fair game for any other development that needs to be developed. Is that what we're saying?
I think, sorry, Sorry, Gillian, it's just the important thing here is that the council cannot demonstrate the 5-year land supply. And anywhere that we can get development, especially where we consider the location to be sustainable, then the NPPF overrides any other provisions that may be in place. So that is the situation we're in this case. This is a sustainable location. Yes, we don't have the 5-year housing land supply, and so we have to give more weight to the fact that we will be able to get sustainable housing in this location. Thank you, Chairman.
Thank you, Kemi. Councillor Barnes, is it still a question for officers, or we're moving to debate? Move to debate. Carry on, Councillor Barnes.
Yes. I'll do this tech.
I think a number of factual questions have come up which probably do need a degree of clarification, because from local knowledge one does need, I think, to admit and say that there is a small greengrocer there, as I understand it, in Station Road. It is not a general store. Eggs and Apples is the only general store now in the village. The community store closed some time ago, which was in the Roman Catholic Church. And so Eggs and Apples is the only general store, and that's the one that is up towards Swift's End. The remaining service points are all in Swift's End, which is to the northwest, northwest of the village. I wanted just to say I wrestle with 11D because it seems to me that at first sight, as somebody who knows this site very well, this is highly intrusive on the landscape. It's very visible from across the valley, and indeed from parts of the valley. And anybody who knows that stretch of the Rother knows that it is an unspoilt landscape, which we have taken good care in the past as planning officers not to break the skyline. Those who are familiar, and there are very few now, I think, on this council, will remember that when we had the development at Etchingham, we were not allowed to break the skyline of the Rother Valley. This development will clearly break the skyline and be visually intrusive. And to my mind, therefore, it falls very squarely under 11D little one, that it would do substantial and irreparable harm. I'd be interested to know why the officers differ from that. This is not tucked away. It's not concealed even by woodland. It is a very open, very large field. I would be concerned about the drainage from it because there is no drain under the A21 and there is no gully on the far side. But drainage is not in front of us. But whether this could become a viable site without major drainage works, I think is real. But to my mind, it falls at the first hurdle. This does irreparable harm to the AONB in this particular area. I'm therefore minded to, I don't want to close debate down earlier, but I shall be minded, I think, on that ground.
I think we haven't had a debate yet, so we need to make.
But I don't want to close debate at this stage.
Okay.
The two other points I want to make. One is, it is relevant that this is about the only green space left, which really separates Hurst Green off from the remainder of Berg Hill, which lies in Etchingham. There is a distinct difference between the character of the two sides of the road. On the north side of the road, what has happened over the years is a linear development of houses which are buried away in the woodland of Berg Hill. They therefore blend into the landscape in a way which is not true of the south side. On the south side, it's very much more broken up, particularly in Etchingham, but even here. And indeed, when the last development was permitted opposite Burwood House, that was deliberately oriented and designed in a different way. It wasn't a linear development at all. It was designed to close the village. And this is why the neighbourhood boundary was actually set as it is. And therefore, in a sense, the neighbourhood boundary was very, very specifically drawn to include that particular close, but to go no further, because we wanted to keep a green wedge between the villages. And so the character here matters greatly. The other thing which is highly relevant and is tending to get forgotten is this is an ancient routeway. And you will totally destroy the character of that by suburbanizing it with pavements. It's a very curious proposal because this is a pavement which will actually link at the Etchingham end. There is no footway at all. So this pavement will suddenly come to an abrupt end. But it doesn't actually link to the footway in Hurst Green. There will be a gap, a substantial gap, between the end of this footway at both ends. What you'll have done is suburbanise the routeway for no conceivable gain to pedestrians. Indeed, I would argue loss, because I think what will be the impact of having a pavement there and suburbanisation will be to encourage cars to speed, which they don't do at the moment.
Thank you,
this, frankly, is a major walking route for pedestrians, for cyclists, for those walking to the station. This is probably one of the most traversed routes on foot, and you are actually encouraging traffic to move faster. And you're also destroying an ancient hedge, which is, at the moment, the home of dormice, who are a protected species. If you tear that hedge out, yes, you can plant a new hedge, but you're not replacing that hedge, which is hundreds of years old. You will take 60 or 70 years before that hedge begins to attain its full maturity. And you will have destroyed the habitat of the dormice. So there are a number of subsidiary reasons which make me against this. But I have to say the major one is this is up on a slope. And rather like the development of Plimwell or the one at Etchingham, you should be very careful not to break the skyline of an outstanding feature of the High Weald.
Thank you, Councillor Barnes. We've got your views across. There we are. Anyone else who'd like to speak? Questions? Debate? Question? Nothing? No? Councillor Groner.
Yeah, just following on from what Councillor Barnes has said, it is first and foremost a highly sensitive area, and therefore consideration of an outline plan is quite difficult because we don't know the nature of it. You know, we don't know the exact nature, but in principle, there's a reason why these three development boundaries have been left like this repeatedly. And I know it's very tempting when you look at a map from above and you go, oh, look, all these houses, and there's a gap. Wait, great, let's go for it. But I don't think that flies when you're in the AONL. So I'm not comfortable with a lot of this. I'm not comfortable with it. And it's specifically the development boundary, hedgerows, of course, as John has said. And then we get on to the tilted balance, which is calculated across the whole county, as our head of planning has told us. But we know 50% of people live in Bexhill, which is completely different to the rural, diverse, sort of small, fractured communities that dot around the landscape. So it's probably like saying we don't have enough houses in Coventry, so let's go build in Hurst Green. You know, it's not a good statistic. It needs to be based on the local housing needs, which has been presented by the Hurst Green Parish Council, and I think their information seems to be the most prescient to me and will be informing my decision.
Thank you. Any further members would like to add, move a motion, or? Councillor Byrne.
Can we move to a vote? I move acceptance.
So you're moving the recommendation by the officers. Let me just read it out. So the recommendation is to resolve to grant outline planning permission delegated subject to conditions in completion of a section 106 legal agreement into relation to the affordable housing provision biodiversity net gain. Yeah. Do we have a second? Councillor Bayliss. So we got a proposer and we've got a seconder. We know we've opened a debate. No one seems to want to debate it anymore. So we have a vote. Could please clearly vote, because clear for.
Could the committee please consider, at least, if they're going to vote for outline, to at least have it come back as a full application? Can we be assured of that?
Yeah, the head of planning has said when the reserve matters come, if it was passed or whatever happens after today, you could then call in the reserve matters to the planning committee. You press your mic on, please, Councillor Barnes.
I'm torn on a procedural point. I would want, at the very least, to amend that, if we were going to approve it, to take out the provision for the pavement and the hedge, because frankly they don't add to the safety, they will detract from the safety. So even if we were to go for the outline in principle, I'm afraid I would.
Yeah, Councillor Barnes just receiving advice, so they're saying because we've got a motion before us, so we have to take the motion first, and after that, if that's lost, we will then look at an amendment you could propose.
Councillor Barnes wanted to motion before.
Yeah, didn't propose, didn't second it, unfortunately. So please leave your hand up clearly. Those in favour of the officer's recommendation for Burge Hill, please raise your hand. And those against? Any abstentions?
Chairman, obviously that motion has fallen. I would like to advise councillors that this application on this site, in this location, even though it is an area of outstanding natural beauty, where it's for an outline permission that could be just one house, up to 7, that it would be extremely difficult to defend with the council's current housing land supply position. So I don't know what the next vote might be, but I feel that that should be a piece of advice for members.
Councillor Barnes.
Sorry, Chairman. Where this highly visual... Where we're dealing with a highly visual site, I really do think 11D little 1 applies. I do listen very hard to Gillian, but I really think even one house here would be visually intrusive. But we're not asked for one. We're asked for up to 7. Yeah. And I move, therefore, that we refuse the up to 7. If somebody wants to come back for a lesser number, they can put in a new planning application.
Chairman, I have to be clear with members. The fact that the wording of this proposal is up to 7, that when it came in as a reserve matter application, if they proposed 7 and you felt that that was too much and would be harmful, then members could refuse it at that time. but I would suggest that you cannot refuse this outline application because it's for 765 for any particular number. It is the fact that it is up to 7. It could potentially be just for the one unit.
Do we have to vote again?
Sorry, I am opposed to even a single house on this site.
And I think
that is why I'm moving refusal.
So we have a move for refusal. Do we have a seconder for the refusal? Polly Gray. There we are. Polly Gray. So John Barnes. Can we have the specific wording for the refusal, please?
I rely on 11D. Little 1. It does nothing to conserve and enhance the AMB and actually does irreparable damage to a highly important landscape, namely the landscape overlooking the unspoiled.
I can hear you. I need to talk into that thing.
Chairman, if I could just
Yeah.
have a collaboration.
Outside the neighbourhood boundary, yes. Jimmy, we ought to mention that it's outside the development boundary. There are a number of other...
Chairman, I think it's quite clear the harm that Councillor Barnes is referring to the AONB in relation to the quoted part of the NPPF. Officers are, I think, satisfied that we understand what the members are referring to, and we will also add the other relevant policies from the development plan, because that's just a technical matter really to do that. In terms of the other matters, because you are seeking to refuse planning permission, then we would pick up the issues of the affordable housing and things, because we cannot have a Section 106. So we'll pick up anything that we would have determined through conditions or through the Section 106.
Yes, there are one or two secondary grounds. Obviously, the removal of the hedge is one, the outside the development boundary is another, the effect on an ancient routeway is a third.
Chairman, can I very strongly advise members that more reasons for refusal is not better. You need to be absolutely clear that every reason that you put on to any refusal is robust in its own right. Otherwise, when it comes to an appeal, you will be subject to costs, even if you won the appeal on one of the other matters. So be very clear that we need very clear, substantial, robust reasons, not any additional ones.
Sorry, I'm not adding on for the sake of adding on.
No.
The outside the neighbourhood, outside the development boundary is a factual statement and really should be included. I think the effect on the ancient routeway myself is a strong reason, but they are protected.
As a highways matter, and they haven't refused.
General impact.
But we're not to, I think, as the leader, head of planning has said, not to elaborate too much in multi reasons. If you're refusing it based on you think the damage to is demonstratory to the AONB, that's your reason.
Chairman, I think a lot of those points can be, about the hedgerow, etc., can be picked up in terms of your broader impact on the area of outstanding natural beauty.
Here we are, so we have a motion, sorry. Councillor Byrne. So one at a time, please, this is getting there.
Thank you, Chair. I'm a little confused. I moved the motion to accept. That was defeated roundly.
Yeah.
Isn't that end of?
No. got to approve it.
You still have to get to an outcome. Stop clapping, please. No more.
My intention was to bring the...
No, because it could have been amended, it could have been amended. We have to have a clear-cut vote for refusal, yeah, if we're going to go down that loop.
Okay.
Also to clarify...
We just need not talk amongst ourselves, please, just talk one at a time.
Councillors, the motion was defeated. However, you need to put forward reasons for refusal because obviously the applicant will appeal the council's decision. So it's that process that we need to go through to make sure there are clear planning reasons to reject the application, and that's on the basis that any appeal will go ahead.
That's what I was trying to move us on to.
Thank you. So we have the motion for refusal, which is demonstrable. What's the...
So, Chairman, sorry, this is what I've picked up from what
This is the motion, so please pay attention.
Mr. Barnes have sort of expressed. So we are basing it on paragraph 11D in terms of the harm to the AONB, and you do not consider that any proposal, which is up to 7 houses, that any proposal on the land would not conserve the landscape character of the AONB. So we've got policies DEN1 and DEN2 of the local plan to support that. So does not conserve, does not enhance, and impact on the landscape, overlooking the unspoiled open space. Is that what you're saying? Said, including removal.
Yeah, we could delegate Oliver, delegate to officers.
I'm just pulling all the points together so we know what we're going on. So removal of the hedge as well. Combination does not conserve or does not result in demonstrable harm to the AONB. That's what you're saying. Yeah.
Could I just sort of say the coach did stop and we did look at the view from the allotment site.
We have a refusal.
Have we got any? Does any part of that long view right up to Cooksfield from the A21 not figure in our refusal?
That is a subjective view, so that's not.
Chairman, I mean, I think members have discussed it, debated it. You know, it is from the motion that's been moved, it is that this development would be harmful to the national landscape, AONB. It's not just the long view, it just would be harmful. And there will be different levels of harm within that, whether it's from the long view, whether it's from the lane, whether it's related to the hedgerow. That will all form part of this one reason that you have.
Anyway, thank you. So we now have a motion proposed by Councillor Barnes, seconded by Councillor Gray. All those in favour of...
Is it development boundary in there?
It'll just be included within that subsection, delegated.
Do you want to finalise the wording and then after the break we can approve?
No, delegate to officers to agree the extra wording fully.
Chairman, I think, just to say to members, I think Councillor Barnes and others have been very clear with their view that this development will have this adverse impact on this national landscape. And there are many factors that contribute to that. We don't need to list at this time each of those individual factors in a reason for refusal. They may form the basis of our case at appeal, but the overriding issue and the summary of it in the reason for refusal is the harm to the AONB. And I think officers have clearly got that message.
No, that's just, it will be included within that.
I don't know. Chairman, the reason I'm struggling is I'm sort of, the fact that it's outside the development boundary in itself, you know, I wouldn't say is a reason for refusal. I don't know if my colleagues would. It's the impact of the development on the broader landscape that is the reason for refusal. Planning is, I mean, there are some, you know, there is policies and things, but obviously, which we have to adhere to. But I think it can form part of the council's case that it's outside the development boundary. But are you suggesting that Councillor Barnes includes a specific reason for refusal, that it's outside the development boundary? And if you are, can you express what the planning harm related to that is that isn't already covered in the reason for refusal?
I think I'm happy to leave it with the officers.
Yeah.
It seems to me that when you look at the local plan and the DASA, which renewed the policies in 2019, and you identify the policies,
They can't hear you at the back.
Sorry. When you look at the DASA, which was the last reiteration of the local plan, or indeed at the local plan itself, it's very clear that there are certain policies for what should happen outside the development boundary in the high wheeled protected area. Those policies, I'm sure, will be listed by the officers.
I think we're going to move to the vote now for the refusal. Councillor Bayliss.
Yes, can I just say that I'm very disappointed that we're losing some units of affordable housing in this.
We move to the vote. So it is contrary to officers' advice, voting for refusal. This is of the application. So we've got a proposer, seconder. All those in favour of refusal? All those against? And any abstentions? One. So that is lost. There we are. I think we're going to refuse. Sorry if you've refused. It's carried. That vote is carried and has been refused. Just to let you know, we're going to have a 10-15 minute break. So, councillors, please don't talk to each other. Please don't talk to any of the applicants, agents, relevant stakeholders. Thank you.
Thank you. Thank you, Councillor Stanger, for taking that last application. We now move on to agenda item 8, application RR 2024542P, Colbeck House, Colbeck Hill, Battle. The proposal is for a detached dwelling. This application is on the agenda because it was called in to be considered by the committee by the ward councillor Catherine Field, and the recommendation is that it be resolved to grant full planning permission. There is no public speaking scheme applicable on this matter today, so the planning officer, Michael Vladanu, will present his report to the committee and will then be asked questions by the committee members before they begin their deliberations. Just before they do that, though, Councillor Burton, who is the other ward member, will also address the committee. Right, thank you. Mr. Vladanu, please.
Thank you, Chair. Good morning, councillors. This application relates to the site at Colbeck House, as shown on the site location plan and Google Earth image on the next slides, and seeks permission for the erection of a detached dwelling. The application site is within the development boundary for Battle and has been allocated for the development of approximately 5 dwellings under policy HD2 of the Battle Neighbourhood Plan, which forms part of the development plan for the district. There is, therefore, no objection to the principle of development of the site for a new dwelling, and in line with the presumption in favour of sustainable development paragraph 11C of the NPPF, the National Planning Policy Framework, states that for decision making, this means approving development proposals that accord with an up-to-date development plan without delay. With regards to the impacts, the national landscape, the dwelling would be set in the large rear garden of Colbeck House, as you can see from the site location plan and the Google Earth imagery, and would not be readily visible from the street scene due to the existing built development on and due to it being sited in the rear garden. There may be some views of the proposed dwelling from the public right-of-way, Battle 29A, which lies to the south. However, views would be largely screened by the existing vegetation, and in any event, the development would be seen in the context of the built development associated with the Battle development boundary fronting Colbeck Hill. Regarding design, as you can see on the next slide, the dwelling has taken reference to the existing dwelling, Colbeck House, portraying its hipped roof, materiality and fenestration, which ensures the design of the dwelling is in keeping with its surroundings and of a scale commensurable to the adjacent buildings at the Dodo House. As such, it is not considered that the development would have a harmful impact on the highway's national landscape, subject to conditions regarding smart glazing, materials and landscaping. The development would meet and exceed the national design space standards for internal space and provide an adequately sized rear garden in line with policy THG7 of the DASA local plan. Parking with turning facilities for 2 cars is provided on the site, and the access is through an existing access with good visibility to either side. As such, it is considered that the new dwelling will not have an adverse impact in terms of highway safety and will provide adequate off-street parking facilities for a 3-bedroom dwelling in this location. Regarding ecology, the 2 trees present, as you can see in the plan, to the north and south of the proposed dwelling, these are said to be retained, and the East Sussex County Ecologist has been consulted on the application and has no objection to the proposal and has advised that the development can achieve a minimum of 10% biodiversity net gain in line with the requirement set out in policy HD2 of the Maid Battle Neighbourhood Plan, which can be secured by a condition. And also in line with policy HD2, the site is within an archaeological notification area, and the East Sussex County Council archaeologist has been consulted on the application. The county ecologist raised no objection to the development subject to conditions which are included within the officer report. To conclude, the site is within a sustainable location which has been allocated for the development of approximately 5 dwellings under policy HD2 of the Maid Battle Neighbourhood Plan. There is no objection to the principle of development of the site for a new dwelling, and in line with both local policy and government guidance, the revision of the new dwelling on the site is considered to represent an acceptable and sustainable use of land, which would have a satisfactory impact on the environment and neighbouring residential amenities. The application is therefore supported for approval, subject to conditions. Thank you.
Thank you, Mr. Bradley. Before I call on Councillor Burton, there's 2 things. One, I meant to say I have got a note from Councillor Field as to why she called that in, why she called this matter in, which I'll read to you. Then I'll mention something else. But I'm able to come to the meeting. My comments are: the neighbourhood plan identifies this site, but 5 houses as a ceiling, not a target. This is owed for development of a site high and visible in the national landscape. 2, the exit onto Colbeck Hill is already difficult and further building will make it worse. 3, the street scene here is semi-rural with individual well-spaced houses. More housing on this site will undermine this. Will you please make my comments available to the committee, which I have done. And then just wanted to point out to members that this was on an update circulated yesterday. We had received additional comments from the applicant, Mr. Whistler, which has been circulated to members, and also an update or further comment from Battle Town Council on the conditions, and I'm advised that all those conditions mentioned by Battle Town Council are actually included on this application. Thank you. Councillor Burton.
Thank you, Chair, for this opportunity. We had a very useful site visit on Tuesday, which I joined the meeting, and I was able to point out the great usage by local residents for the footpaths, which are adjusted adjacent and to the back of the proposed development. I support Battle Town Council's comments, and I have worked with the planning officer to reduce loss of the green spaces within the which I think has been productive. And we have also discussed the specific native planting that would be beneficial, which I hope will be included in conditions if this application is agreed. Thank you.
Thank you, Councillor Burton. It's now question times of Mr Vladnik. I'm going to start with one from actually Councillor Burton's point about the native planting. Has that been included in the conditions?
Yeah, that has been included in conditions. There's a few conditions that would be included in, so we would seek that as part of a discharge of condition to ensure that it is a native hedgerow and its appropriate mix as well.
Thank you. I just did that while it was fresh in my mind. Right, are there any questions for the officer, please? Councillor Ganley.
Thank you, Chairman. I'm wondering if anybody knows why Battletown Council says it is contrary to the neighbourhood plan, when the neighbourhood plan provides for, I believe, up to 5 dwellings on the site. And, well, that's all. I don't know why they would do that when it's within the neighbourhood.
I think I asked and answered that when I was reading it myself, but I'll come to the officer because he can answer it for me and I won't get it wrong.
Yeah, just to clarify, the development is within the development body for Battle. I believe the original objection from Battle Town Council was due with ecology, because the specific policy HD2 requires 10% biodiversity net gain. I think at the time that they commented, there was no ecology report. That has subsequently been submitted, and their new general comment has no objection to it now. I believe that was the main issue that they raised at that time, but that has since been addressed, and I think that's mentioned in their new comment, that they've just a general comment, no objection, and they just want to see the conditions. So I think that answers the question.
Thank you, Michael. Councillor Stanger.
Yeah, just mostly that question I was going to ask about, because Battletown Council, I believe, now are just a comment and not an objection. Yeah, just to clarify. Thank you.
That was the update.
Yeah,
yesterday, that's why I mentioned it. Sorry. What it was yesterday was the Town Council notes that the proposed development is within the neighbourhood plan as an allocated site. They do, however, recommend that conditions are imposed to ensure the development is in line with the allocation. The conditions requested would include details of electrochromic glass, materials, bike storage and archaeology, and that's what has been included in the conditions. Councillor Bayliss.
Yes, is it possible at this stage to move that we adopt the recommendation? That we resolve to grant?
Just before. Sorry, I have the microphone off. I'm just going to finish question time definitely and then see if there's any comments before we move to that. But thank you, it's registered. Are there any more questions? Thank you. Councillor Gray.
Michael, can I just ask you on paragraph 9, A, you say the trees have got TPOs, the beech and the oak, is that right? But you say there would be measures for their protection in the course of development. I think that beech tree is very close to where the building's going to be. Are they going to leave enough room so they don't disturb the roots? Is that what you mean by measure of development protection for during the development?
Yep. So the application is supported by a tree survey, and that details measures to protect trees. The county ecologist has reviewed that, and they have advised that the measures within that report are adequate to ensure that the trees will be protected during construction and throughout the course of development. So there'll be no dig zones, or it'll be protective tree barriers, and that's secured by condition. So the condition requires them to to be in accordance with that.
Thanks, Michael. Can I just ask you another question? I noticed the houses that have been built there, there's no solar panels, they look, they don't look at all eco-friendly. Can we make sure that this building, if it goes ahead, is more eco-friendly?
I don't think we can impose that at this stage. We just have to go with what's being presented, and there's no details of any renewable energy measures a part of that. Maybe a case that they may come forward for an air source heat pump or things like that, but as part of the application submitted, there's no details of that, and there's no policies in the local plan at the minute. They may potentially come forward in the new local plan, but at the minute there's no requirement for that. But it may be a case in the future.
Thank you. Still on question time, Councillor Barnes, then Councillor Groner.
Yes, I wonder if Michael can actually just outline the impact of the southeast elevation, what actually lies to the southeast of this building. I can't pretend that I think it's a very pretty design, and it clearly is going to appear a very lit wall. Will it have much impact? You minimise the effect of the light, but it'll still be highly visible for some way because this is an elevated. And I would welcome also Michael's comments on whether this really fits in with the design of the surrounding buildings.
So to answer the first question in regards to the south-east elevation, the south-east elevation of the proposed dwelling mimics that south-east elevation of Colbeck House with the large glazing. In regards to the condition, it is considered that the condition is adequate to minimise light transmission. So in regards to that, we would seek to have at least 50% reduction in visible light transmission. To the south-east, members would be aware, there is a section. It's an open field. I'm not sure if it's ready to be used. It is within the ownership of the applicant, but it wasn't, from my view on the site, it wasn't used for agriculture. It was just an open field, and then there was a tree line just on the bottom, so that would sort of limit any light spill. But yeah, to be assured, there is a condition on to significantly reduce light transmission. There will inevitably be some light, but that would be seen in the context of the built development fronting Colbeck Hill. So there shouldn't be a lot of light spill out with that specific condition in place. In regards to design, I'm not sure if members know on site, but from my point of view, along Colbeck Hill, there's quite a mix of developments. Even within the site, I believe there's quite a mix. You've got the main house and the other buildings. There were different materials, there were different fenestrations. So I think for this dwelling to match that of the main house would tie it in. And there's no specific wording in the policy HD2 that says it has to be, of a specific design. It's just taking into consideration of the surroundings. The surroundings are mixed. It ties in the main dwelling, so it's considered to have an acceptable impact in that regard. If there's anything else. Thanks.
Thank you, Michael. Councillor Groner.
Is density of the plots at all a consideration? Because I'm just looking along the road, everything seems sort of spaced out, but this is sort of right up against the next house. And is it owned by the same people, or is there any objection from the neighbours there? Because it's...
So yeah, it is owned. From my understanding, it was owned by the applicant's father, who's since passed away. So I do believe it's still in ownership of the applicant. It's not within the blue line boundary, but I do think it is. But that building there it's a garage. It's not a house. It's an outbuilding. Okay. But in regards to density, in the report, it should be outlined. There is quite a bit of backland development, so development behind that frontal to the front and also to the east. So in that regard, it is in character. What I would say is that the site has been allocated for approximately 5 dwellings. Only one house has been built since that allocation has come in, so there could potentially be another 4, and that would be assessed if any further applications come in about density of the site. But in this case, it's considered to be acceptable. It provides for the amenities. Yeah.
Thank you. I think that's for questions. Does anyone want to make some comments or discussion? Otherwise, not, I shall. Yes, okay. Councillor Groner first, and then Councillor John Barnes.
Yeah, just to say that when we did the site visit, I walked down into the field itself below, which is at a much lower level. And when you look back at the house, you have, you know, a house which is really nicely set back with a big lawn and trees, and you sort of try to picture a building there. Now, I think it was Councillor Burton who mentioned there were some paths running along, and I don't know what sort of weight that carries, you know, walkers and stuff, but it is going to have a big visual impact, I think. Just from standing below, you suddenly just go, wow, this nice open place with a big house and a nice garden, and then suddenly there's another house. So I don't know how much weight that carries, but it didn't feel great looking back up on that onto that plot of land.
I would imagine if it's allocated for up to five houses, not a great deal. But your point is well made. Thank you. Councillor Barnes.
Yes, the visual impact on Corbeck House, and I don't know whether Corbeck House is listed, is obviously pretty harmful, but there we go. That's the way it is. I must say the importance of this site potentially for the archaeology, I hope is adequately met by the conditions. I think it is, but this is one of the possible sites for the Battle of Hastings, and therefore, since no weapons have been found on the traditional site for the Battle of Hastings, this one does need to be looked at very carefully from the archaeological point of view. So this one is one where the archaeological clause really is not a matter of rote. It needs to be taken very seriously. I have to say, though, the pass in a way is sold. This is in the neighbourhood plan. I don't like the design, I confess, particularly the design of the southeast elevation. But we are going to mitigate the light, and I think that our skies policy does really matter on Corbeck Hill, because it will be quite visually intrusive on the AONB. But it seems to me approval already in principle for 5 buildings. You cannot say no to this building. Therefore, I'm happy to support.
Thank you, Councillor Barnes. No, we've already moved. You're going to be third or fourthing it at the moment, Councillor Barnes. But I will probably come to that. I'm just going to say, isn't it wonderful? Whoever thought I'd be talking about the Battle of Hastings at a planning meeting in 2024? But there we go.
And I thought the Corbeck Hill was the site of Harold meeting before the Battle of Hastings. I think that's, it's not the battle itself.
I wasn't around at the time.
It's where Harold assembled his troops.
Thank you. The point was well made, and I just wanted a nod from Michael that the archaeology is very, very important on this.
Yeah, 5 and 6 is 2 archaeological conditions, and no development shall commence until that's been accepted.
Right, thank you. With that in mind, it's been proposed. Do you want to say something else? I'm just going to... Oh, okay.
I just wanted to say that thanks actually to Councillor Burton, who took sort of worked really collegiately with our planning officer to make this an acceptable, certainly in terms of biodiversity. And I just wanted to say that that's a good example, I think, for us to look to, really. Thank you.
Thank you. Right, the motion proposed by Councillor Bayliss, seconded by Councillor Stanger, is that we support the officer's recommendation and resolve to grant full planning permission. Those in favour, please. Leave your hands up. So, thank you. That is unanimous. Thank you very much. That is carried. Right, agenda item number 9, application RR 2024-1037P Just a reminder, as previously stated, I live in a road that backs onto Edgerton Park, but this application has absolutely no effect whatsoever on me or my family or anyone I know, so I intend remaining in the room. It's Edgerton Park, Edgerton Road, Bexhill. The proposal is an erection of a 6-metre ball stop netting system on the southern and western sides of the informal kickabout court. This is a retrospective application, and it's before the committee today because Rother District Council is the landowner, and the recommendation is that it be resolved to grant full planning permission. There's no public speaking on this item today, so the Planning Officer, Sarah Shepherd, will present this report to the committee and then ask questions. Sorry, it's Reuben.
Can I reiterate my declaration of interest? Thank you.
Yes, thank you. And also just to mention again that Councillor Byrne, myself are members of Bexhill Town Council, but we're not sure that's totally relevant. Thank you. Sorry, it's Reuben Hayward, and he will present this report to the committee, and then we ask questions before we move on to the deliberations. Reuben, thank you.
Thank you, Chair. Good morning, councillors. This is a retrospective application for the erection of a 6-metre high ball stop netting system on the southern and western sides of the informal kickabout court at Edgerton Park in Bexhill. As previously stated, this application has been referred to the committee because it concerns council-owned land. The application relates to the northeasternmost court at the park, which is used as an informal kickabout court. There have been a number of instances of individuals climbing the existing 3-metre fence to retrieve footballs that have landed in the adjacent tennis courts, raising health and safety concerns and resulting in the closure of the kickabout court. This application is submitted retrospectively because the development has already taken place to ensure that the court was able to reopen during the summer period. The netting is 6 metres high and is supported by a series of green powder-coated aluminium posts. Although taller in height than the existing fencing, the netting system matches the colour of the existing fencing and is not a solid structure, and therefore is not considered to harm the character and appearance of the locality. The proposal is considered to be an improvement of the existing sports facilities in accordance with Core Strategy Policy CO3 and can be supported in principle. The application is therefore recommended for approval. Thank you.
Thank you. Any questions for Mr. Hayward? No. Matters open for discussion. Councillor Barnes.
I'm very happy to move this. I think it's a pity it had to come to a retrospective. That's my only reservation. I think actually this will add to the amenity of the residents and therefore can be supported.
Thank you. Seconded by Councillor Creaser. I think Reuben touched on it. It was if it had waited to come to the committee, they couldn't have used the courts during the summer. So I think that's why it ended up being retrospective. They took a risk that we might say yes to it. So thank you. So the motion is that we grant full planning permission in this case. All those in favour, please show. Thank you. That is unanimous, and that is carried. Thank you. Now, hang on, we've got agenda item 11 coming next. Sorry, 10. 10. I was getting through even quicker. 10. I even saw 10 but said 11. Right, agenda item 10, application RR 2024-398P, Little Common Recreation Ground, Green Lane, Bexhill. The proposal is to remove condition 3 imposed on RR 2020-296P to allow the pitch gates to be permanently locked outside of match times. This application is on the agenda because it is owned by Rother District Council, and the recommendation is that it be resolved to grant full planning permission. The planning officer in this case is Reuben Hayward, hopefully. He will present his report to the committee and then be asked questions. But before he does, we have Councillor Winter, one of the ward councillors for the area, who will be addressing the committee. So, Mr. Hayward, please.
Thank you, Chair. This application follows the planning permission granted in 2020 under reference RR 2020-296P for the erection of fencing around the main pitch at Little Common Recreation Ground, along with the erection of 2 stands and a tarmacked path. This Section 73 application seeks the removal of Condition 3 in order to allow the pitch gates to be permanently locked outside of match times. This application has been submitted following several incidents of dog fouling on the pitch, as well as vandalism of the stands and dugout, leading to unwanted costs for Little Common Football Club, who leased the pitch from the council. The football pitch is surrounded by the remainder of the recreation ground to the south, east and west, with Broadoak Park accessible further to the south and east. With the exception of the main pitch at the recreation ground, which was disposed of as public open space following the agreement of the lease with the council, the remainder of the recreation ground and Broadoak Park is publicly accessible open space. As such, no concerns are raised in terms of a loss of public open space. Following the 2020 application, public footpath 48 was diverted to run alongside the southwestern edge of the pitch before continuing southwards across the recreation ground. The former route aligned with 2 of the gates around the pitch. However, this route is no longer required following the diversion, and no objection has been raised by the East Sussex County Council Footpaths Officer. Footpath 65 to the north of the pitch would also be unaffected, as this lies outside the boundary of the pitch. The permanent closure of the gates outside of match times would serve to deter vandalism of the pitch, and as such would safeguard the existing sports facilities in accordance with policy CO3 of the core strategy. The removal of Condition 3 is therefore supported by officers. Thank you.
Thank you. Councillor Winter.
Thank you, Chair. I wasn't actually planning on speaking on this item. It's item 12, but I do fully support the application and the decision anyway.
Sorry, I put in your name in anticipation in my script, and then you said you weren't going to speak. Right. I'll just make an observation then, as being somebody who supports Bexhill United, who use Polgrove. I wish we had some way of stopping people letting their dogs foul the football pitch and cause damage to the pavilion there. But there we go. I always thought this was very strange when we diverted the footpath that we still said they had to keep the gates open. It was bizarre. But and I suddenly realised I haven't gone for questions for the Reuben before I made my comments. So are there any questions for the officer, please?
No questions.
Councillor Creaser.
I don't have any questions, but I propose that we grant approval.
I suspect that's what Councillor Bayliss was going to say. Right. Councillor Stanger. Oh, I've got thirds, fourths and fifths here somewhere. Right. Okay, and I'm guessing from that nobody wants to make any comments beyond my one. So, proposed by Councillor Creaser, seconded by Councillor Groner, that we accept the officer's recommendation and grant full planning permission in this case. Those in favour, please show. Thank you. That's unanimous. It's coming to an end soon. We'll start on 11. If it comes to 1 o'clock, we might have to.
You can't stop.
No, okay. Once I've started, I've got to finish. So we will start there. Agenda item 11, which are applications RR 2023-796L, which is referred to as application A, and RR 2023-795P, which is referred to as application B. Location is Swan Inn, High Street, Burwash, TN 197EH, and the proposal is application A is the retention and amendment of internal and external alterations, and application B concerns the replacement of timber casement windows. Given the controversial nature of this application and that the ward councillors, Councillor John Barnes and Councillor Emma Kirby-Green, were not able to call it in within the usual timescale, I have called this application into the committee in my role as committee chair under paragraph 318 of part 8 of the Constitution. The recommendation is that it be resolved to grant application A, listed building consent, and to grant application B, planning permission. The planning officer in this case is Michael Bladanu, and he will present his report. And before he asks, one moment, yeah.
I'm not declaring an interest on this, but for the sake of transparency, I ought to say, as a ward member, I have obviously been involved in some of the discussions about enforcement, which of course is not a material planning consideration. I've taken the advice of the monitoring officer on this, and she advises that process and this particular planning application are separate, and therefore I'm in no sense predetermined. Indeed, I'm not. I have a totally open mind on, because clearly some planning application is going to be necessary. It's a question of the exact terms in which we grant or not grant that may be worth exploring. But I have an open mind at the moment.
Thank you, Councillor Barnes. Right, so I'll say after the planning officer, it is subject to the public speaking scheme, and we'll have the Burwash Parish Council clerk, a neighbour and a representative of the applicant talking to us, and also Councillor Kirby-Green, one of the ward councillors, will be addressing the committee, and then we will ask questions of the officer. So if you please, Mr. Vladimir.
Thank you, Chair. Good afternoon, councillors. These applications relate to the site at Swan Inn, as shown on the site location plan, Google Earth imagery, and photos shown on the following slides, and follows on from a previously withdrawn application at the site and pre-application advice with extensive discussions. Application A refers to the listed building consent application RR 2023-796/L, and application B refers to the planning permission application RR 2023-795/P. Members should be aware that application A, the listed building consents, relates to the whole works. However, application B, the planning permission, solely relates to the replacement timber casement windows. The applications seek to address works that have previously been carried out to the listed building without listed building consent or planning permission. The unauthorised works, as described within the applications, consist of the following: 3 number UPVC casement windows installed to the rear, the removal of the staircase, insertion of a new staircase of shallower pitch, and the formation of a new stair accessway, the installation of dry lining and installation of walls with Celotex and plasterboard, the fixing of steel plates to the timber structure, installation of plasterboard ceilings with downlighters, the demolition of stud walls and formation of ensuite bathrooms, replacement of the soil stack to the rear, replacement of doors within the building, and installation of rock wool roof insulation. The proposed works seek to reverse many works carried out where possible, with some amendment and retention of some works. The following works are now proposed: removal of 3 number UPVC casement windows to the rear and replacement with timber casement windows, retention of new staircase and new stair accessway from living room, removal of Celotex and plasterboard dry lining insulation, retention of steel plates to the timber structure, retention of ensuite bathroom at first floor level, retention of soil stacks to the rear of the building, retention of replacement oak doors within the building, and the removal of the rock wool roof insulation. The drawings and details submitted with this application and shown on the slides detail that the areas where the modern materials have been utilised, Celotex, plasterboard dry lining and insulation, would be removed and reversed, as can be seen on the red diagrams on the floor plans. The use of vapour permeable materials, lime lath, ensures the historically significant timber frame is preserved in the long term. Remaining on the second floor plan, if Sarah can get that up, it is noted that the plan form of the master bedroom, which is annotated as bedroom 1 on the slide, has been significantly altered by way of the installation of an ensuite bathroom and dressing room. The ensuite and dressing room has been formed by way of modelling the second bedroom. Whilst it is large, it would still occupy the same footprint as the former bedroom it replaced, and regarding plan form is considered consistent. The rear bedroom, described as bedroom 2 on the plan, had been previously subdivided to form a bathroom in a very dominant manner, being half the size of the room. The works have removed this partition and installed a more appropriately sized, smaller ensuite, as can be seen in the top right hand corner. Thus, in terms of legibility of the original room, the new work is considered to bring about some enhancement and heritage benefit. Externally, much of the building is unchanged, with the exception of works to the rear elevation, including the installation of various extractor van vents, UPVC wastewater pipes and soil stacks, and the installation of UPVC casement windows. The use of extractor vents is accepted on the basis that modern bathroom habits, such as showering, create excess humidity that needs to be mechanically extracted. The replacement of the UPVC windows to the rear with a more appropriate material, timber casement, as shown on the slide, is welcome and would provide an improvement to the existing. The replacement windows would be in keeping with the character and appearance of the building and would have a positive impact upon the setting and wider character of the conservation area and national landscape. Finally, regarding the staircase, it is acknowledged that the harm to the historic interest by way of its removal is permanent. Whilst the replacement staircase is a modern addition, it is within the same location as the previous staircase, albeit it has a shallower pitch, resulting in a slightly longer overall length, which has required the removal and insertion of panelling and relocating its access. There is no change at first floor level. In concluding, the Council is obliged to consider the architectural and historic interest of the building and compliance with local and national planning policy. It is the officer's opinion that the works set out in the proposal generally reverse the previous unauthorised works that are considered to cause harm to the building. Application A, the listed building consent, it is considered that having regard to Section 16 of the Planning, Listed Buildings and Conservation Areas Act 1990, the proposed, by virtue of reinstatement of plan form, use of vapour permeable materials, and reinstatement of correctly proportioned timber windows would preserve the architectural and historic interest of the listed building in accordance with Policy EN2 of the Core Strategy and Policy GP01 of the Burwash Neighbourhood Plan. And finally, in regards to Application B, the planning permission, it is considered that after having regard to Section 66 of the Planning, Listed Building Conservation Areas Act, the proposed, by reinstatement of correctly proportioned timber casement windows, would preserve the architectural and historic interest of the listed building and would have a positive impact on the character and appearance of the area within the conservation area and wider national landscape, and as such is policy compliant. So in the next slides, there is some photos. So as you can see on the top, that's a photo from 2019, once before the works have done. To the bottom, that is the works in 2021, after the works have done, and these are taken from the sales particular. These are the kitchens, the same orientation. On the top is the work before the works in 2019, and the bottom is post works in 2021. That's just a photograph of where the original staircase was before the works. So as you can see, it's quite steep. Steep threads and dog legs at the bottom. And the next slide should see, so where that panel is, So the new panel to the left of where the old access was has been removed, and now that panel has been inserted. And that's where the new stairs, that's where the access for the new stairs is. So it was just slightly moved to the left, and a new panel has been put in where the old staircase was, and that's a view of the existing staircase in as present in 2023. So it is a shallower pitch, and it is slightly longer than the previous staircase. Thank you.
Thank you, Michael. Now that the officer has presented his report to the committee, we move on to the public speaking section of the meeting. Each speaker will have up to 5 minutes to address the committee based on their previous written submission. New information cannot be introduced at this stage of the proceedings, and I will interrupt anyone who is still speaking at the 5-minute mark. As I call forward, if the speakers could introduce themselves, we won't start the clock until you've settled and ready. And we don't want to go home yet anyway, by the sounds of it. So the first speaker, please, is Emma Neal, Burwash Parish Council Clerk. Thank you. Oh, sorry, Emma, in front of you, there's a little picture of a voice. Right-hand button, you press that to speak. That's live, and then press it again to turn it off. Thank you.
Thank you, Chair. My name's Emma Neal. I'm the Clerk for Burwash Parish Council. Thank you for letting me speak today. I'm speaking on behalf of Burwash Parish Council in their objection to the retrospective planning application in relation to Swan Inn House. This property first came to the attention of the Parish Council in 2019 when unauthorised works took place to the property, and in April 2020, when I started as Clerk with Burwash, I spoke to the enforcement team about the Council's concerns. To date, no schedule of enforcement has been given or discussed despite numerous attempts to obtain the information. As a parish that has an overwhelming amount of listed and heritage buildings, the Parish Council is more than aware of the time and effort it takes to conserve and protect Grade 1 and Grade 2 listed buildings, and of the financial impact that this protection can have. Many residents in Burwash observe the important planning laws and listed buildings policies that are in place to ensure the heritage assets aren't lost. The Parish Council do not understand why officers are holding the residents of this property to different standards and allowing unauthorised and potentially structurally unsound works to be approved retrospectively. If the correct channels of application had been made in 2019, it is almost impossible to see how approval would have been given. This doesn't seem a fair approach to residents of Burwash or the surrounding parishes, and it is in danger of setting a very real precedent of retrospective applications when dealing with listed properties. The Parish Council feel that little or no consideration has been given to the impact structurally on the neighbouring property. The 5 houses that now make up this section of the High Street were at one time one building with a staircase at each end. Swan Inn House is the last house in the row. In removing and remodelling the staircase at Swan Inn House, this has potentially made the neighbouring structure unsafe. Officers have made no attempt to provide conditions that allow for a full structural survey to be carried out at the applicant's cost to ensure that any works that have now been done don't impact the neighbouring property. A full complaint has been made to Rother by the occupants of the neighbouring house and is currently being investigated. There has been a lot of interest locally in this retrospective application, and the lack of meaningful enforcement is at odds with other district councils neighbouring Rother, where fines have been issued for lesser works completed. A number of residents have contacted the Parish Council expressing concern that their applications have taken many changes, been made at many years, and have had huge financial cost before they were allowed to carry out the work, whilst this application is seemingly approved by officers. At the very least, Burwash Parish Council would like to request that the committee defer this application so that a full site visit by the Planning Committee can take place and a real understanding of the schedule of works can be clarified, along with a better understanding of the very real impact on the neighbouring property by commissioning a full structural survey and a commitment by Rother to follow the enforcement plan and issue a formal notice to right the damage done and to further ensure that Rother are not allowing criminal damage. Thank you for your time.
Thank you. Any questions for Emma, please? No? Thank you. Thank you very much. We now have Louise Robinson, a neighbour, speaking against the application. Thank you. You okay with the button and the right-hand one with the voice on? Yeah, that's it.
Good morning. I'm here today to strongly object to the application for retrospective planning permission sought for Swan Inn House, a protected historic Grade 2 listed property built in the time of Henry VIII. This was once one house comprising of Swan Inn House, Signet Cottage, Lime Cottage, the Old Granary and Yew Tree House. The key points of my objections are: the application is for retrospective consent to remove and or retain internal alterations. There is no specific permission sought for the removal of features and fabric of the house. It is rolled into one phrase, retrospective consent to remove internal alterations. As far as I understand it, no consent is sought for the destruction of the pretty courtyard garden in order to urbanise it. This forms part of the curtilage of the listed building, is now an eyesore and not in keeping with the cottage of this period. The destruction of part of the ground floor to insert a lavatory. The removal of historic panelling on the ground floor, the destruction of the historic gap between the kitchen and dining room and the removal of rails, the complete remodelling of the cellar and removal of historic parts. There is also no consideration for damage caused to the chimney to the extent that the local chimney sweep stated at the time of works it was structurally unsafe to clean, damage to the ground floor and the first four flying freehold elements of adjoining property, Signet Cottage, where the applicant's builder tried to remove shared beams during the removal of the staircase. The committee are now expected to consider this vague application without even a site visit with images to compare the property before the destruction. The applicant purchased this 16th century Grade 2 listed house in 2018, fully aware of its historic status. Yet between September 2018 and September 2019, the house and its historic features were gutted and extensively altered without proper permissions in direct contravention of the Planning, Listed Buildings and Conservation Areas Act 1990, which clearly states that it is a criminal offence to carry out unauthorised works to a listed building. Dan Bevan, Head of Enforcement of Rother District Council, was aware of the unlawful activity while the illegal works were taking place in January 2019 and had photographic evidence of the damage, yet he did not issue a stop notice and no enforcement action has been taken over the past 6 years. This is in direct contravention to the policies laid out in Rother's own enforcement plan 2022. My concerns about this have now been raised in a live Stage 2 complaint against Rother Planning Department. As such, I'm very concerned that Rother Planning were complicit in this criminal offence and are now asking you, the committee, to also be complicit and vote in favour of this retrospective application contrary to Rother's own enforcement plan 2022, page 17, section 18. Approving this application sets a very dangerous precedent of not only allowing those who break the law to be rewarded over those who follow the legal process, but also a complete failure to protect buildings of historic relevance for future generations. I am asking that you defer this application until a proper comprehensive report is drafted outlining all the unlawful works, the required restoration and a plan for enforcement. You insist that the applicant provide a structural survey by a council-approved expert assessing the safety of the chimney and other structural elements, including those shared by Signet Cottage. You insist that the applicant submits the pre-sale survey report, which may shed light on the property's condition before their destructive renovations. It is my understanding that the applicant is refusing to supply this. Why? Make it clear that any further non-compliance will result in enforcement orders and criminal proceedings. Arrange a site visit for the planning committee to see the extent of the damage with your own eyes. Only then can the committee make an informed decision that properly safeguards this historically significant property. Allowing this application to proceed as is would be a travesty of justice. I urge the committee to please take a firm stance and defer this matter until it can be properly addressed. Thank you.
Thank you, Louise. Any questions? Councillor Ganley is first, I think. Councillor Ganley.
Thank you, Chairman. Hello, thank you for your presentation. You mentioned damage to a courtyard. There's nothing about that in the report.
I know. It's been completely omitted.
Ignored.
Yes.
What was the damage?
They completely gutted the entire courtyard, so they removed the whole of the courtyard. They then put in limestone with stones, yes,
Yeah.
without any drainage. The drainage is really poor, so it just floods. They put in, they excavated the adjoining wall, which was an ancient wall, which they just completely excavated and put a fence around it and caused significant damage to that to the wall. And then they put in an enormous fully grown tree, which has just grown out of proportion and is also blocking light and creating some issues with root growth.
I'll ask officers why it was not included, but you also mentioned chimney, the problem with the chimney?
Yes.
That's all?
No, I know.
What was that? What was the chimney sweep said it's dangerous
Yes,
to clean?
we share the same chimney sweep who does, Nick Kennedy, whom some of you might know. He does that area. He has been doing both properties for many years. And he was asked to go in and sweep the chimney when the works were in place. And he refused to do so, he said, because falling bricks were coming down the chimney and he felt it was significantly unsafe to do so. Yes.
He felt, well, it doesn't matter what
Because
you
of the works, yes. Because it had been previously okay.
Yes.
Yeah.
Reasonable assumption, I would have thought.
Yeah, presumption.
Thank you very much. Assumption, I agree.
Are there any questions? Any other questions for Louise, please? No, thank you.
Thank you.
We now have Natalie Presland, thank you, who is speaking on behalf of the applicant. Thank you, Natalie.
Thank you for the opportunity to speak regarding the case of Swan Inn and Mrs. Val Camp. My name is Natalie Presland. Mrs. Camp is my mother-in-law. She owns Swan Inn and lived there. And Neil Camp is the applicant, and he is my husband. Both send their apologies. Mrs. Camp's unwell. I'll move the speaker. Yeah? Here. Shall I start again?
Yes.
Yes? Thank you for the opportunity to speak regarding the case of Swan Inn and Mrs. Valerie Camp. My name is Natalie Presland. Mrs. Camp is my mother-in-law. She owns and lived in Swan Inn. And Neil Presland, the applicant, is my husband. Mrs. Camp sends her apologies for her absence. She's too unwell to attend today. And my husband could not get off from work. We've met with Rother Planning Department, including the Conservation Officer at Swan Inn, in order to discuss what works were needed to rectify the building work from 2019-2020. At the meeting, we discussed in detail every issue with the Conservation Officer, and an agreement was made on all remedial work. A work schedule was agreed. The internal insulation to be removed, replaced with lime mortar, as agreed with the Conservation Officer. PVC windows to be replaced and wooden bespoke new windows, as agreed with the Conservation Officer. When the original building work was conducted, a structural engineer's report was commissioned, as it was deemed that the main building support was unsafe, and the conclusion of the report was to secure the main load-bearing beams with steel supports in order to make safe, as agreed with the Conservation Officer. Regarding the stairs, during the renovation works, the staircase was found to be dangerous and unsafe. Its condition was so bad, any repair or salvage was not possible. Years of unchecked woodworm and rot had done its damage. It was beyond repair. The structure and fabric of the staircase was so degraded that it was a significant danger to users, and it failed to comply with current regulation. The pitch of the staircase was 54 degrees, extremely steep, you might have noticed it in those photos, and deemed excessive. It was not fit for purpose for general domestic use or as a safe route of egress in an emergency. So the staircase had to be replaced, and it was done sympathetically to the original. New staircase had been built using the best and highest grade materials and complies with all regulations. It's been replaced with a custom-built oak staircase at significant costs in line with the heritage of the building. The construction dimension and material all complies with Document K and the Equality Act 2010. Pitch of the stairs is now 42 degrees. Building Regulations 2010, approved document, Part K1, Stairs, Ladders and Ramps, 2003 edition for use in England, is clear about the pitch and construction of domestic staircases. The staircase also complies with the Equality Act 2010. The Equality Act, sorry, I'm racing through because of the timing. The Equality Act 2010 prohibits discrimination against people with the protected characteristics that are specified in Section 4 of the Act. Mrs. Camp is a registered disabled person and suffers from rheumatoid arthritis and has macular degeneration. Physical impairments can result in mental effects, and mental impairments can have physical manifestations. Mrs. Camp has now moved out of the property as her health has deteriorated due to the stress and worry over this matter. She's eager to get this matter resolved. It must also be mentioned that if in an emergency, the staircase is the only entry and exit point for the first and second floor, and therefore it must be safe to use when exiting the building in an emergency. The current staircase satisfies this. Regarding the objection received regarding damage to neighbouring properties, this is the first instance that we have been made aware of this. Swan Inn is an end of terrace with only one property adjoining it. Works were carried out approximately 4 years ago. If there had indeed been any damage, it would have been assessed immediately and the necessary action taken. In fact, we do also have Nicholas Kennedy as a chimney sweep, and I would need to talk to him personally, but he spoke to us following any previous work, and nothing was mentioned about any concerns from our side. What else do I need? The garden, if I can mention that quickly. Drainage has been put into the garden. The tree been planted. Mrs. Robinson, the neighbour, complained about the light, and further action was taken. I think somebody came out to have a look at it, and it was deemed okay. I need to clarify those details, but certainly it had been raised at the time of the tree going in, and that was sorted. One other important thing that was just raised. Oh. The wall, I don't believe, was removed. I think it was just covered up with some sort of screening. But it was deemed to be very wobbly at the time, and I know that conversations were raised at that time. This is the garden that I'm talking about. It is a matter of public record that there is a history of discord between both Mrs. Camp and Mrs. Robinson, and to the extent of she was knocking on Valerie's door and walls 11 o'clock at night, complaining about noise from the TV. Mrs. Camp called the police, and actually it was all deemed that it was the noise that was totally acceptable, and I was there.
Thank you. Your time is up.
Thank you.
Questions? I've got Councillor Ganley and then Councillor John Barnes. Councillor Ganley.
Thank you, Chairman. Thank you for your presentation. Why was it decided to proceed with major changes to a listed building without applying for planning permission?
Mrs. Camp had instructed a builder who she believed to be totally in the know, and she's 80 years of age, so she trusted everything that he had to say.
You trusted a builder with everything you had to say?
She did, yes.
I used to do some property development.
She said he used to work for the planning department, I think, of Maidstone or whatever. So yes, she was led astray.
I don't know where to start.
Well, don't. Let Councillor Barnes go what you think about it. Councillor Barnes.
Yes. Sorry, I've struggled to hear you, so maybe you've covered this. Did you know the property in 2018? Or have you only seen it since the alterations?
I went around it once, so I knew it then, but no, I couldn't tell you really in detail, but I did attend it once. It's on.
A survey was done in 2018. Has that been made available to our conservation officers?
I believe anything, because we were on the cusp of agreeing with the schedule of works, we had a meeting with the Conservation Officer and the planning. We provided them all the detail. They were happy with the schedule of works, and we were ready to proceed.
Yeah.
The
Right, thank you. That's really one aimed at the Conservation Officer later. Very shortly, because he is present. So the Conservation Officer will be available. He's now a consultant, but he is here today for questions afterwards. Any more questions of this speaker, please? No? Thank you. Thank you very much. As I was about to say, when we do get to question time, we've got Simon Richard, who was our Conservation Officer and is now a conservation consultant that we address on issues. But first of all, I have the Ward Councillor, Councillor Ellen Kirby-Green. Yes, I know, the mind goes all over the place. Councillor Kirby-Green.
Thank you. I'd first like to make it quite clear to the Planning Committee that despite what has just been spoken about, this is not a neighbourhood dispute. You're being asked to legitimise criminal activity, which in other authorities would have been prosecuted, resulting in a hefty fine and in some cases a custodial sentence. The work here took a year. In a cottage of this size, that gives you some indication of the scale of the destruction. If the applicant had requested planning permission 10 years ago, it would never have been granted. This officer report to committee seems to be incomplete in places and not always very clear. It is giving the applicant a blank cheque. There is the absence of any reference to the impact on Signet Cottage, which was once part of the same property. We are supposed to have regard for their amenities, and indeed the report raises only to dismiss questions regarding light and privacy. I can imagine no greater intrusion than an attempt to move a beam and the actual removal of a staircase doing visible physical damage to a party wall. To date, the applicant has refused to have a party wall survey done. They have been aware that there are complaints from the neighbouring property. What has been supplied with the application is a limited structural survey from 2022, which includes loads of disclaimers, which suggests that the chimney may be insufficiently supported. It is not at all clear on whether the apparent movement of the beams is down to the removal of a load-bearing wall, the shift in position and restructure of the staircase, or to other causes. It is unclear whether the structural problems with the chimney have been addressed, and should the chimney collapse, this would undoubtedly affect Signet Cottage as well as Lamb in-house. As with numerous other aspects of the remedial work to be done or the changes legitimised, there is a lack of careful and detailed specification that would allow us to know and check that the necessary work has been carried out to our satisfaction. There are a number of historic features to this property which undoubtedly were there in 2018 and which seem now to have either disappeared or been obscured. For example, the 17th century panelling, which are not dealt with at all in the committee report. There are too many grey areas where it is unclear what we are approving or indeed what is to be preserved or restored. Where work is being done on a listed building that has received consent, it is staged and each stage monitored. It is not right that people seeking retrospective consent should be treated more favourably than someone who is willingly going through the necessary hoops. However, that is exactly what we are doing here. There is a quote in the report that the applicant doesn't want to reinstate the staircase due to costs. That's extraordinary. Lots of applicants have to make changes during the application stage before they are given permission at great expense. They don't have the option to say no. What message does this send out to not only the residents of Burwash, but the residents across Rother? 95% of the buildings in Burwash High Street are listed. What would happen if all the residents of these houses chose to behave like this? I will leave you with a quote from David Martin, who is a leading expert on timber buildings and one which the Rother District Planning Authority is very aware of. I think it is disgusting that this work should have gone ahead in the first place and no subsequent action taken. Indeed, I have used this to demonstrate how planning seems to have gone back to the 60s and early 70s in its treatment of historic buildings. Thank you.
Thanks. Thank you, Councillor Kirby-Green. now come to question time of the officer, and I say this includes questions of Simon Richard. So questions, please, from anyone. Councillor John Barnes.
Yes, I think my first question is probably to the officer concerned, and I would want to acknowledge, I think, that he has been put in an almost impossible position by the applicant in trying to prepare this report. That said, is he aware of the gaps in the information provided? There are areas of change which have not been listed at all, to which we're being asked to give blanket approval. Why aren't those specified? Why is no justification provided for those changes? If we were having a planning application, we would normally have justification from the applicant of why those changes were done. And the third question, was the 2018 survey made available to him, which is the only full survey that appears to have been done. The only survey that has been submitted is a partial survey with the application. So I would like to know whether he's seen the 2018 survey, which may indicate the further the scope of the work, which is clearly not outlined in his report, and I want to know why.
Thank you. May have to come back for some of those questions were repeated because it was a big chunk.
Yeah.
I think I'm going to ask the conservation consultant first to perhaps address. Well, between you two, you decide who's going to answer. I think both of you probably.
Just before we start answering the questions, would it be okay, Councillor, if we just did some clarification of the law under the Planning Listed Buildings and Conservation Areas Act, so we can give some context to the application that's been received and how the recommendation's been made and the councillor's duties as far as the law is concerned, because that is why we're here making a decision on listed building consent. I'd like to turn to Section 7 of the Act, which states, subject to the following provisions of the Act, no person shall execute or cause to be executed any works for the demolition of a listed building or for its alteration or extension in any manner which would affect its character as a building of special architectural and historic interest, unless the works are authorised. Another relevant section of the Act is Section 8, Part 3, paragraphs A and B, which refer to the ability for a person to make a effectively retrospective application for listed building consent. And it reads as follows. Works for the alteration or extension of a listed building are authorised if written consent for the execution has been granted by the local planning authority and they are executed in accordance with the terms of the consent and any conditions attached to it. I will turn and speak about the conditions in a short moment. The final point that we have to also separate out is accusations of damage, malicious acts being carried out upon the listed building that are outside of the remit of the application laid before myself and the planning officer. Those issues would come under Chapter 5 of the Act, the prevention of deterioration and damage of listed buildings, which is a separate element to listed building consent. Okay, so thank you for giving me the opportunity just to clarify the law there. So we are talking about works that impact the architectural and historic interest of the listed building, okay, not necessarily de minimis works. I'm not saying that parts of this application are de minimis by any sense, but there is a sense there of the extent of the council's powers under the Act. I just want to check with my legal colleague if that's, she's nodded and smiled, so that seems about right to me.
Yep.
So can I just have a refresher on the first question, if that's okay? I'll let Michael deal with the first question, thank you.
Yeah, so in regards to the first question, in regards to the information, so there was a previous application submitted back in 2021. It was a different officer, I wasn't involved with it. And then there was subsequent pre-grab. I've reviewed both of them applications that I was reviewing this, and there's everything that was in the previous applications and pre-app is contained within this. So it is the same as what was submitted in 2020. So there's been the evidence before me, taking into consideration all the evidence that the council holds, is that these are the only works that I have evidence have been carried out. So therefore my judgment has been made on the evidence that I have been provided, and that's formed my decision. In regards to justification, I feel like in the report there is justification for it. As stated, there is some areas that are going to have permanent damage, but it's considered overall that it's considered in the public benefit to get the works removed, to allow the listed building to breathe and to be preserved in the future. So that's what I would say on any potential other works. And potential the courtyard, I don't believe this needs listed building consent, works to the courtyard, so they haven't been included within the application. And then, yeah, and like Simon said, in regard to damage to party walls, it's under separate legislation. And in regard to the structural survey, which I think was a separate question, it's just the information that's been submitted on the website, which I believe is the most recent structural survey, which is 2022. There was some correspondence previously in 2019, but it's just a 2020 survey that's been submitted. I don't know if Simon's anything further to add.
I just want to also make clear to the councillors that this has been an ongoing and long application. Initial reports to enforcement, I believe, were 2018, 2019. My tenure as conservation officer at Rother District Council didn't begin until November 2021. So it was already several years old when I arrived. This also led to ultimately decisions initially a long time ago, prior to any of the staff that are working on the case now, coming to a decision then not to take immediate enforcement action. So a process of planning applications, pre-application advice, so on and so forth, was then brought about in subsequent years to get where we are today. And just a final sort of point on that is, with regard to the works that have been carried out, currently today they are unauthorised works. They are, not authorised. The council has the power today to make the decision as to whether they are going to authorise the works and thus make them legal or otherwise. And the recommendations have been made in the report for your consideration.
Yeah, I was just going to say, the third question specifically was, have you seen the 2018 structural report? That's
2022.
No, there was one before. It was just, had you seen the one preceding?
No, only the 2022 one. Yeah.
Thank you.
That in itself is telling, Chairman, but missing from this, the problem is we ask give blanket approval to changes which are not even listed. All the doors have been changed. Literally every door on the ground floor has been changed. The panelling may be there behind the stub wall, may not, we don't know. But has that been removed? That's 17th century panelling, specifically mentioned by David Martin. David Martin did 3 extensive surveys of this property, which was part of a row of 5 dating to the early 16th century, not the 17th. And why are these other changes not listed either by the applicant or mentioned in the report? Is my question to the officer.
The basis of a decision on an application is based upon what is provided in the report. In an enforcement case, we can act on the basis of the evidence that we have, and the evidence that we had was photographs provided from the sales particulars prior to Mrs. Camp purchasing it. There are certain elements with regard to the panelling, for example, that if it was covered previously to those photos, we would not know when they were removed. So whereas David Martin may have surveyed them on a particular date, there would be no evidence to say that this particular applicant has removed those things and therefore contravenes Section 7 in respect of that panelling. We need evidence to be able to take particular matters forward. We do have evidence of the staircase removal. We have photographs showing the original staircase in place. We do have photographs showing a different staircase in place, and the owner and the person responsible for making listed building consent applications at that time is definitive and clear. Whereas in other respects, it is not definitive and clear, particularly in the case of the panelling. I do not condone works to a listed building without listed building consent, but the circumstances in which we are in has led to a scheme being proposed that reverses a lot of the long-term impact to the listed building. We cannot retrieve a 17th century staircase, it's gone. But what we can do is make sure the historic fabric of the building is suitable for the long term by reinstating traditional materials, enhancing its vapour permeability and breathability to stop ongoing rots. That's what myself and the planning officer have strived to do based upon the limitations of the circumstances that we're in.
Thank you. I'm just going to come to Gillian McInnes first, and then it'll be Councillor Gray. I've got a couple of others. Gillian.
Chairman, just to say that in paragraph 3.2, it sets out the list of unauthorised works, and it refers to replacement of all the doors within the building. So that is part of, that is recognised as being something that has happened in the building. I think I would just like to follow up on the Conservation Officer's comments in terms of that nobody here would condone unauthorised works to a listed building, but that the approach that is being proposed before members is about trying to ensure the future of the building, and that the materials that are currently harming the building would be removed and replaced by those that would enable it to breathe, that the windows would be replaced with the timber windows. So this is not an ideal situation by any means, but in terms of looking forward to the future, because in itself, the prosecution of, under the Listed Buildings Act, would be a punishment for the person that is now responsible for the works, the owner. However, it would not necessarily get us further on in terms of the protection of the building. So I think nobody is in, I want to leave everybody in no doubt that officers do not think that unauthorised works are the way to go on a listed building. They are not. But in this case, we are looking at what has happened and how we can reverse as much as possible. In terms of other matters that have been raised, if I can just share while I'm saying something, is I want to be very clear, things like party wall issues, issues to do with actual land ownership issues between neighbours, they are not relevant to your consideration at all. Works that harm the listed building, potentially listed building, can be relevant, but not any land ownership issues. Thank you.
Thank you. So I've got Councillor Gray, then Councillor Bayliss, then Councillor John Barnes. Councillor Gray.
Thank you. I was just wondering, if this approval isn't given today, if it's refused, then what happens?
Effectively, the works would remain unauthorised, and therefore then it is up to the council, because it's a decision to be made more widely as to where we go next with the particular case, which could involve enforcement or revision of application, for example.
And if members refuse it, obviously the applicant can appeal.
Councillor Christine Bayliss.
Yes, thank you. This is, I know this is a we are where we are type situation, but something seems, there's something that tells me this is all against natural justice in terms of there are rules that we have to follow. I can't understand how anyone could think purchasing a Grade 1 listed building, a Grade 2 listed building, but even something that is listed would not involve some sort of requirement and permission. I mean, the solicitor must have told the purchaser when the building was purchased that they would require permission. So something says to me, why have we not gone down the enforcement route as well as getting the works done? Why are we allowing the enforcement to not go ahead?
So the question is, why aren't we doing both at the same time? Is enforcement and trying to put it right. Simon.
So,
and I know, sorry, before you start, I know a lot of those initial decisions were made when the officers weren't here and it was somebody else, and they set the council on a particular course, which I can then see people saying, well, that's unfair if you change it halfway through, but Simon.
We're not pursuing enforcement action at this time because an application is currently under consideration under listed building consent. Once that application is determined, unfortunately, it's the way the law is written.
Please let the officer carry on.
Unfortunately, it's the way the law is written, okay, unless works are authorised. If a person has made application for works to be authorised, whether under Section 7 or Section 8, okay, we have to determine that application, and then once it's determined, the council can take a view as to what action to take afterwards.
And I suspect this is me talking off the head and I'm waiting for an officer to shoot me down, is that even if it was prosecution, we'd still have this application before us at some stage, whether or not the person was prosecuted. And I suspect one or other would have said, we'll have to wait till the other one's decided before we can decide that one. Because that is British law. It's madness. I don't know if Kemi wanted to add to anything Simon said, or Gillian, or we'll move on. Specifically about why we're not doing both. Or did Simon cover it? I think he did.
Thank you, Chairman. I think Simon has already covered that, and the main bit here is that we've got an application before members. You have to decide or determine the application, and then whatever happens after that, we will determine the course of action we take next. However, you have to also be mindful that any decision, if it's a refusal, is subject to appeal. So we have to wait for the end of that. If it comes back differently on appeal, then that means that there won't be any need to take any further action in this sense. Thank you, Chairman. I hope that answers the question.
Thank you. I've got Councillor Barnes, then Councillor Stanger, then Councillor Groner. Councillor Barnes.
Yes, I'm grateful to Gillian for reminding me that the replacement doors is mentioned in the list. And I accept what is said about the panelling, that you, although it's very firmly there in the 1996 report, and indeed in the 2 earlier reports that David Martin's prepared, I must say, though, the assumption that previous owners have behaved illegally is a pretty dangerous one. The sales particulars do not suggest that the work had been done. We know the staircase was there. You haven't been given access to
just remind you, it's still question time.
But I'm going to ask a question under 3.2. There is an opening with railings in between the living room and the kitchen. That has now been closed up. That is identifiable from the photographs, is not listed under 3.2. Do we take it that it's unauthorised, or do we take it we are legitimising that? And we're being asked to legitimise a lot of things, which frankly, I could go through a list. I've spotted a number of omissions where we're being asked to authorise things which have neither been documented nor in fact justified. And I must point out, sorry, I'll answer the question, I'll make the point later.
Chairman, I'm not quite sure what the question is in there, but I'm going to go for a punt on the 3.2 and 3.3 are a summary of all the works, but the application is not just the application form, it is all the plans and documents that relate to the application. So other works in terms of the physical changes will also be included in the plans. I don't know if the conservation officer is in, or the
so
case officer.
My question is, it's an incomplete list. Does it mean that those elements that have not been specified, that are clearly unauthorised and are evident from photographs, are now going to be approved?
I think from what Gillian was saying, and I'm looking at Michael now, is that yes, it's for the report, it's a list, and it may not complete every single detail, but the attached plans have more details on them. Because I think Simon made reference to the fact that it was looking to remove the major blockage to the future of the building, and as you say about doors, it's suggested that the doors are retained because that's not crucial to the longevity of the building. I'm thinking that, but I'm waiting for any officer to rescue me or just say, yes, you're right, Chairman. Michael looks like he wants to say something. And say
yeah, so all the works are detailed on the plans. They all are on the plans, and they would be approved plans. So anything on the plans, shown in the plans, would be approved. In regards to the doors have been replaced, but it's good quality. It's good quality oak doors. It's not, just any old door. But yes, to answer your question, they are on the plan. That's just a list of summary of the major issues that require done first, essentially to preserve that listed building. But all the details are either in the application or shown on the plans, on the floor plans, which are labelled what's to be removed. There's annotations on them. There's also conditions as well. For the schedule of works that Simon might be able to comment more on. So there's going to be a lot of detail, and there is safeguards in there for each stage. So I don't know if Simon's any further comments.
I'll just quickly touch on the conditions because they are relevant to the case, and it also does send a message that our recommendation is not effectively a free ticket, as some people have described it. Okay, we want within 3 months of the approval date a full schedule of works and methodology for every single item that's been approved on the scheme. As far as the works to reverse are concerned, we want to make sure those works actually happen. So a condition has been put in for a photographic record to be submitted at various stages, which are detailed under condition 4, and showing the fullest extent of the works at each relevant stage as we have seen fit to specify. And we also have included under condition 5 the development shall be made available for inspection at any time. So it is part of my, should the approval go forward, it'll be part of my work and the enforcement officers to do regular unannounced inspections to make sure the works are being carried out to reverse the harm to the listed building and ensure its ongoing conservation.
Thank you. I've got Councillor Stanger, then Councillor Ganley, then Councillor Byrne, and I'll start again.
Yeah, thank you. Yeah, it was really to do about the works and how we can ensure, but the conditions, I think they've been mostly answered about the conditions cover the strict time limits, and if they didn't do that within 12 months, what would be the result of that?
It would be a breach of conditions under listed building consent, so we would be able to take further action if the council saw fit to.
Thank you.
Thank you. Councillor Ganley. Just a reminder, this is still question time.
Oh, question time, yeah.
Oh, no, sorry, one moment. One moment.
Yes.
You'll come later. I've got TG, it was not Tony Ganley.
TG.
Councillor Groner, you were next.
Oh, Tony Groner.
Sorry. Okay, I'll come back to Tony Ganley. Councillor Ganley.
I'm not surprised, actually. I'm starting to lose the will to Olivia. Good luck, by the way, with working with enforcement, who are, with an authorised budget of 5 FTEs, are down to 2.5, and indeed today, 1.5, because one of them has gone on holiday. So there's 1.5 staff, 1.5 FTEs in enforcement when we need more. It's my big bugbear at the moment, was constantly. Anyway, I'm not going to bang on about that. What about the courtyard and the chimney? As you heard a speaker refer to them, the courtyard would be part of the curtilage, so I imagine that is considered to be part of the listed building. What has been done to it? Sarah's shaking her head, I may be wrong here. We'll soon find out.
Sorry.
And what about the chimney?
Sorry, Councillor Ganley. Councillor Ganley.
Let me finish.
Yeah, no, but I want you to speak to the microphone, not the person. No, leave it in front of you, but speak to the microphone, not the person. Thank you.
I know, I've been criticising everybody else, and now I'm doing it myself. Anyway, yeah, chimney and courtyard, thank you.
Okay, in respect of the chimney, I defer to the planning manager's earlier comments about party wall agreements. There has been nothing that has been raised as part of this application process, and I need to stress that, which enables me to consider those bits under the application if they are indeed an issue. Also refer back to my earlier point about a different section of the Planning Listed Buildings and Conservation Areas Act, which comes under Chapter 5, the prevention of deterioration and damage. There's clearly some dispute regarding that. Turning to the courtyard, listed buildings do have a curtilage, but development works that are carried out in the garden completely separate from the listed building and not subject to listed building consent. They're subject to, if it's defined as development, I might add, subject to planning permission under section and is considered under section 66 of the Planning Listed Buildings and Conservation Areas Act, which has due regard to the setting of a listed building.
Thank you. Councillor Byrne, then Councillor Bayliss. Councillor Byrne.
That's me, yeah?
Yeah.
I can never hear Burton and Byrne.
Councillor Byrne.
Thank you. Just to sort of summarise where we are, first of all, I was going to make the point about putting a time limit or a time constraint.
It's question time, Councillor Byrne.
Yes. I was going to ask whether it was possible to put the time constraint on. I believe that has been answered, that it is, and we have. Is that correct? Secondly, I believe the point was made that this is because, if we grant this, we're not granting a blank cheque, and we're not precluding ourselves from taking further enforcement action on other unauthorised alterations. Am I correct in assuming that?
I'm thinking the answer is yes, but I'd like someone to say it.
No.
Oh, 1 moment, there's a disagreement here.
Sorry, Chairman, we're probably coming at it from slightly different directions. In terms of this sets out the works to the building, that's what's in the plans, that's what's in the application. If something else happens, then that action could be taken on the something else. But what's in front of you is the works that are on the plans and referred to in the application. Is that?
And also, if I'm right in thinking, as was said earlier, if it's granted and the conditions aren't followed,
then we could take a breach of condition notice.
So again, clarification, you say if something else happens, is that also if something else has happened?
Yeah. I like that. That's an attempt to draw a line going forward so that if something we don't know about has happened. I like that.
Or something we do and isn't mentioned in this report.
I suspect...
My legal advice, and I'd welcome the lawyer's comment on this, because it didn't come from her, is that nothing that we do to legitimise the works precludes action for criminal activity.
I was just going to say that, and I think also we are not the controllers of the enforcement. That is not the planning committee's job. So
it is planning.
It's planning, but it's not the committee's remit to direct the enforcement.
But it does fall under planning, correct?
Yes.
So then the natural order of things would be...
So I asked a question.
Sorry,
everybody's still talking, so
Sorry.
I haven't.
Kirsty.
Obviously, as Head of Planning has set out, the application before you sets out the works together with the plans. So that is what you're determining today. I'm not quite sure what you're asking in terms of anything else, because everything is included, presumably, in the plan
The
submitted.
advice to me, which I'm checking with you as our official advisor, is that the granting of planning permission retrospectively does not preclude action to prosecute for criminal activity, even if we've legitimised the work subsequently.
But what was set out was once, if you approve the application, you're authorising the works. So you're
Yes,
legal.
but not authorising the breach of the law, which is absolute and not time-bound. In other words, the criminal activity is taking place. We are being asked now to take stock and work out a way forward, but we ought not to be letting the perpetrator off the hook.
I mean, that would be a matter of enforcement that would be outside of the remit of the planning committee.
A quick conversation behind me. You're going to be next, Councillor Bayliss, with your question. Because we're still on question. We haven't even got to comments yet.
Thank you, Chairman. Sorry about that quick confab. I just wanted to make sure that we were both on the same page. If members today accept this application and the works are undertaken in accordance with the conditions, then the council would not then prosecute. We would not prosecute because the applicant had done, or the owner had done works that they shouldn't have done, because we have now accepted a route out of that. So in terms of legally, if you went before the court and said, this happened, the council then approved an application, the applicant or the owner undertook all the works in accordance with the scheme, you know, that we are proposing here, and we'd now like to prosecute them. That would not, the court would throw it out. That is not something that would go forward, in my view, and that was concurred with by the solicitor.
Well, it's your time for a question now, anyway.
I've got two questions now. My follow-up question would be, if we refuse this application, it still leaves us open then to pursue enforcement action. That would be the follow-on from what you're
If you refuse the application, the works are unauthorised. So then there's another question in terms of what the council would do about that. And that's the works that are set out in the application and in the plans, not anything, any additional works or damage to the building. So that they are unauthorised works, as the Conservation Officer clearly set out earlier.
Can I ask my original question, which was, is it possible to defer? Because I don't feel that I have enough information to make a proper decision today. I would actually like to go and have a look at this with my, you know, I know I'm not a historical expert, I'm not a conservation officer, but I really would like to look at the plans, look at what's been done, so with my own eyes I can see and make a decision. But I mean, I normally would never defer anything because I think that's a wimpy way out. But on this occasion, I sort of feel that's what I want to do. Can we do it?
We can, but I very much don't like the idea of punting it down the road. But
I'm sort of maybe answering a question with a question. I'm not sure how much would be achieved. I mean, I don't know whether Sarah can go backwards on the slides, but we set out, there was slides there that showed the before and the after. But you might not have noticed, because to the I'm not, so this doesn't sound insulting, but to the untrained eye, it is actually really difficult to see some of these changes. But the issue is we have experts to advise us on the historic fabric of the building. And in the slide before you now, you can see the top, oh, sorry, Sarah, could you go back? The top photograph, you can see more beam in that photograph than in the lower photograph. The ceiling is much more flush with the beam. That's the sort of, and that is because they've used, I think, Celotex, so they've used the stuff that is in my house, it's built in 1968, that is the thick insulating type material, whereas that isn't acceptable for a listed building, and that's the type of adjustment that you're seeing. But Sarah can go through the rest of the photographs. It is unusual for an entire committee to go inside a person's home. I'm not saying that it wouldn't be possible, but, well, I don't think the lady's living in it, but it's still her home. So in terms of these, I mean, Sarah can go through the slides, and again, you can see the difference between the upper slide and the lower slide is, yes, the beams have been lightened, but that's not, say to me whether I'm wrong, but that isn't something that would be of concern from a historic buildings point of view, but there is more Celotex and therefore less beam displayed. But that's what is proposed to change. So you're not going to see what the proposals to change are because they're in the plans. So I would question what would be gained by deferring.
So the answer is yes, you could defer, but I must admit I would be against deferring for those very reasons, because all you'd be looking at is what's been done, not what is going to be done. Councillor Grinder, do you remember?
Yes, well, maybe it's a fresh one. But I guess it's a really boxed-in situation here that a lot of us, I think, feel very, very uncomfortable with, because if we're finding a practical solution, which is what officers are trying to do, is find a practical solution to move forward, get this done. However, the big question is 5 years and no enforcement action. It's just like, and then the minute that we do find the practical solution, we're setting, well, there's no precedent, but there is consistency. And as Councillor Kirby Green pointed out, I mean, that area of the countryside is awash with these old houses. And I just think this is a really, really kind of sensitive thing. And we're being pushed into a corner here in a way I don't think is comfortable. To make this judgment without seeing any enforcement, I think it is part of the parcel. I know we have to consider what's in front of us, but it is part of the parcel and the law's been broken.
We're still in question time with the officers, not comments. Councillor Barnes.
I listened with some care to Simon's outlining of the statute that governs all this. There appeared to be, and I haven't got the Act in front of me, Simon may have the Act in front of him, a way of authorising certain works to be done without necessarily granting planning consent. That's within the power of a planning authority, I believe. In other words, the works that put right, what we're worried about, what Simon is worried about, what we're worried about, is the longer-term harm to the building if certain materials are not removed. We could authorise those works, I believe, under the statute, without giving planning consent to the changes. What worries me is not actually the giving of planning consent, it's giving listed building consent when we're actually making ourselves complicit in illegal activity.
I think that's a nice question.
Sorry, can I just confirm? You're not making yourself implicit in any illegal activity. As the local planning authority, you have an application before you for, well, two applications, one for listed building consent and one for planning permission. So, you know, you're duty bound to determine the application that is in front of you. I don't think it's making anybody or any members implicit in any illegal activities.
It was just your microphone, Councillor Barnes. Yeah, as you say, when we get on to discussion. Are there any more specific questions for any of the officers? Thank you. We're now moving into comment and discussion time. Councillor Barnes.
Yes, I'm being pushed to change my mind. I was very open originally to the idea of passing this. I'm beginning to find myself in considerable difficulty. And that's why my last question was highly pertinent. What worries me, and I'm not taking a lawyer's view of this, I'm taking the view of applicants, and I've had numerous in the last 4 or 5 years, who've gone through all the planning hoops, they've carefully justified all the changes, they've spent large sums of money. I can instance Kestrels. I've got Sunnyside in the High Street at the moment that has been turned down twice now on having an extension. Other extensions have been granted, but not without enormous care. Magpies took us an age. All these people are going to turn around to us and say, and you're now letting somebody drive a coach and horses through the law. And that sets an extremely dangerous precedent. And I will use the term precedent here, because I believe it is a precedent. One of the ways around that, occurs to my ingenious mind, is that we could authorise certain works which we believe to be essential to the fabric of the building without giving listed planning consent to all the changes that have been made. Now, that would be a very untidy situation, but it's addressing the very untidy situation in which we've been put in. If I have to vote on anything other than amendment, then frankly, I will have to vote against. The other thing which I really would insist on as a condition, because we talk about the no threat to the amenity of the neighbouring property. I cannot think of a bigger threat to the amenity of the surrounding property than the possible collapse of a chimney, which is shared by both properties. It seems to me, at the very least, there should be a condition in here that we actually ask for an independent survey of the building to make sure that the changes are structurally safe and will not affect the neighbouring property. And it seems to me that's a perfectly proper requirement.
Thank you. And I know this is discussion time, but I'm sure Kirsty will be able to come up with an answer about the picking and choosing, cherry picking the bits from it. But if it does help members, I was already considering taking the two applications separately. The listed building is separate to the... I've now been told that's what I should have been doing anyway. But hey, I got to the answer in the end. So I will be taking separate votes on them. My observation, as nobody else has put their hand up at the moment, and this is only as a member of the committee, is that I don't think we're running coach and horses through it, because we are doing what we're being asked to do, what you've just said, which is put right the things that can be put right. We can't put right the staircase, it's gone forever, and the doors, I suppose, are immaterial. They could be replaced by ancient doors, but they're perfectly good doors. So I don't think we're necessarily setting a precedent in this one, and we're not letting them get away with it. What they're not being is prosecuted, and that goes back 5-6 years to a decision before I was even a councillor. And we are tied by that decision that somebody made on the basis 5-6 years ago. And I find my hands tied with that, because yes, I would love to have prosecuted, I think, myself, but that's gone. That was decided 5 years ago, and we went down a mitigation route, and we're trying to mitigate.
Respect, that is not the law, Chair.
I say that's my opinion.
No,
we're trying to
the
mitigate.
law says that there is no time limit on prosecution when it's unauthorised change to listed buildings. That is in the Act.
Yes, but
no time limit whatsoever.
Okay, so in my humble opinion, my lay opinion is nothing is gained by, because we are, by prosecution, we are trying to rectify and protect the building. Prosecution is an entirely different matter.
And just to clarify, there are lots of considerations to be determined in deciding whether to prosecute. Just got part elements from the guidance for listed building prosecutions. So it says, in the context of listed building prosecutions, prosecutors should consider whether bringing a prosecution which would on the face of it constitute an infringement of the accused convention's right, strikes a fair balance between the public interest in conserving listed buildings and the defendant's personal rights to respect for family life and a home and protection of his property. In justifying such an interference, it is the local authority's responsibility to show what its reasons were and that they were relevant and sufficient, and so a prosecutor should consider whether the decision to prosecute is not arbitrary or unfair, based on relevant considerations, capable of achieving the required objectives, and that refers to planning policy guidance and the use of prosecution as a deterrent. You've got to consider the Council's prosecution policy, the Code for Crown Prosecutors. There's lots of other considerations as to whether the Council would prosecute in this or any other instance, which have to be taken into consideration.
Thank you.
Simply ask.
Can I just say that we have an application, you have a planning application and a listed building application before you. These are the ones that you have to determine. You know, one way or another, that's what's before you. in terms of the picking and choosing and what you might like to or not like to do, then that isn't really what's before you. In terms of, to go back to the chimney, this committee does not have evidence that that chimney is structurally unsound. If the neighbour considers it to be unsound, then that, I would say, because it's on the party wall, that gets back to that issue of it's a private legal matter between two neighbours on the party wall. I've always been grateful that party wall issues are not planning issues. In terms of the planning application of the listed building, they will be taken separately, and I will just remind members that the planning application only refers to the timber windows. It does not refer to any of the internal works, and it's the listed building application refers to everything.
Councillor Barnes.
Yes, I'm sorry, we do have evidence on the chimney. One of the questions that I asked, and needs to be answered, the imperfect survey that was done in 2022, which has been submitted with the planning application, specifically identifies the underpinning of the chimney as not being of insufficient length. I ask again, has that been checked out? Has that been altered? Because otherwise we have evidence that the chimney was thought by that surveyor to be dangerous. He said that there was insufficient support from the coach plate that had been inserted. That's in that report. I've been through this in detail.
Chairman. Was the conservation officer going to?
That we do not seem to have got an up-to-date survey. All we've got is this imperfect 2022 survey, which is confined solely to the coach bolts.
I think I just need to reiterate the point that a listed building consent decision is based upon the information that is submitted as part of that application. If there is a 2018 survey, to my knowledge, and Mark would agree, we haven't seen that, okay, and ultimately we can only make a decision on what is actually proposed, and they haven't proposed to carry out works to the chimney. Now, if there is issue with the chimney, as I spoke about earlier under Chapter 5 of the Planning Listed Buildings Conservation Areas Act, we could then, if the council saw fit, consider whether action was appropriate or not. But it's most likely, as the planning manager already alluded to be a civil situation in terms of party wall agreement.
So we look after their light, we look after their overlooking, but we don't look after the possible damage if a chimney falls. I really think planning occasionally is outrageous.
Yes.
Councillor Canley, you wanted to make a comment?
I was just going through what we're asked is to decide on 3.3, basically. And I'm quite happy with them all. Replacement of the casement windows, removal of Celotex, retention of steel plates. I'm even reasonably happy with the ensuite bathroom. I don't know what a salt stack is, so I can't comment. Replacement of the doors. Yeah, I prefer anyway, they are apparently good, solid doors, so I'll leave that. And removal of rock wool roof insulation. All of those largely, I'm quite happy with. So I'm happy with that. I'm happy with the application B, which is new windows. With regard to these two applications, I see no reason to delay matters, and we can go ahead and vote, if I may say so, Chairman.
Are you, because I've been tripped up with this before, are you moving that we accept the officer's recommendation on application A and application B.
I'm moving, certainly on application B, I move approval.
One moment. Application B is the planning permission for the windows, and A is the listed building.
Yes.
Yes. So are you doing both?
Well, I'm doing
And then I
one.
will listen to the voices that are coming in either side of me.
Patience, little by little.
So you're doing
B.
B, the planning permission for the
I move
windows.
approval for application
And that's
B.
been seconded by Councillor
I'll second,
Stanger.
B.
But I'm now going to listen to the voices that were coming in to my head from other directions, and I'll come to you, Councillor Byrne.
I'm really hungry.
Councillor Byrne, you had something to say.
Thank you, Chair. I was just going to move us back to the first, the very top of the paper. It says, application A, retention and amendment of internal and external alterations. That appears to say we are saying everything about that building at the moment, apart from those items listed in paragraph 3, everything else is fine, retention of. I'm just checking that that is, in fact, what that is intended to mean.
Gillian?
The application comprises the application form and the plans, and some of the works are for retention, like the new staircase, the new doors are examples of that, and some of the works are the removal of the current unsuitable materials and their replacement. So that is what you're looking at. You're looking at the whole of the submission that's come before the committee.
So retention.
Retention would be the new doors, for example, and there are other things, but for example, the
So-
new doors and
so
the new
retention
staircase.
of anything they've done other than those issues we are addressing in paragraph 3.
Anything that's you've got it in the application, what this application comprises of, which is the plans and what's on the application form, and is summarised in 3.
Microphone, John, sorry.
If we could get B out of the way, I would support that. I'm prepared to move the rejection of A.
I don't see at the moment how we can approve B because it follows on from A. I'm having that discussion at the moment, but I'm told I can do it. Yeah, but the removal of those windows is in A as well. That's what I'm saying. It's one of, yeah, it allows them to do that.
It is 2 separate applications.
Although we haven't yet. Yeah, but just follow my thoughts here. We could give permission to do the windows, but if we've not done A first, we're not telling them they have to do the windows.
Chairman, if I can, I mean, and Kirsty might want to come in, but the applications are different. One is for planning and one is for listed building consent. You often require 2 consents to do anything. Whether it means that it will actually be executed is a different matter, but I don't see any reason that you should not determine them.
To
determine
paraphrase,
B first.
get on with application B, Chairman. Yes? Right. So application B, which is the planning permission for the replacement timber casement windows, was proposed by Councillor Ganley and seconded by Councillor Stanger. All those in favour, please, of recommendation to allow planning permission for the replacement of the windows? That's unanimous.
A.
One moment.
Chair? So if we refuse A, for instance, hypothetically, then B is void, or how does that work?
No, B is as it is in isolation in space.
Chairman, you would need listed building consent. Well, actually, I might defer, no, you would need listed building consent to do it as well. So you can't act on B, you've permitted B, but you cannot act on B because you need listed building
Yeah, so
consent
it's,
as well.
it's a bit of an empty kind of...
Yes, but it's two separate.
So at the moment, I've got a proposal from Councillor Barnes to reject the officer's recommendation. Do I have a seconder for that?
What are the grounds?
I'm coming to that one moment. Councillor Barnes, what reasons are there, please, for rejection?
I think that the insufficient justification has been given for a number of the changes made, and I think we need to be fully justified where criminal activity has been undertaken. It is criminal activity, and without that justification, I am not prepared to vote to retrospectively grant planning consent for listed building changes. With the justification, I'll be prepared to consider it, but I don't believe these changes have been justified.
Instead of just using me as a mouthpiece, I'm going to go straight to Gillian to ask the question that I would ask you, Councillor Barnes.
Chairman, I think the fact that it's criminal activity, that's not a reason for refusing the listed building consent. So you have to specify what the harm is in your, if you're going to move refusal, you've got to say what you consider the harm is in relation to the listed building.
The point about criminal activity. I think actually it'd be quite interesting to hear an inspector on this subject. That frankly, I think we are in grave danger if we justify this of encouraging lawless activity on the part of other applicants. But leave that on one side. I think that if we are to justify listed building changes to this extent, because they're fairly massive, they need to be fully justified, and I am insufficiently persuaded that we've got sufficient justification to approve the changes made.
The words I keep hearing up here is about harm. And of course, arguably, the harm is listed in 3.2. All the things that were done.
No justification. If we were
and so Councillor Barnes's point is that's the harm. We've listed the harm, and he's saying we haven't got sufficient justification to permit that harm, as it were, retrospectively.
My analogy would be with a planning application for a listed building consent that had been put in good time, and we would have asked for all the changes to be fully justified and commented on by the officers. We haven't got that. Some are not specified at all. Others are done with no justification whatsoever. I have no idea why, for example, the staircase pitch has been altered. I know that an oak staircase has been removed, but we're allowing the pitch to be altered, which alters the entire characteristics of that building. Why have we allowed that? No justification offered. No justification actually made by the applicant.
One moment, Gillian.
Chairman, one of the, we keep referring to harm, and if you're going to refuse this, you need to identify the harm. But not only do you need to identify the harm, you need to be clear as to why the conditions that are attached to this do not overcome that harm. Because the conditions refer to the works that are proposed. They also include the submission of detail of those works to remedy the use of the materials and the use of the approach that has been taken, particularly in terms of the building and its ability to breathe. When you're saying there's insufficient justification, I'm not sure, and I'll be advised as to whether that term is enough to explain why the proposal that's before you, justified or no, is unacceptable.
Let me try again. Let us assume this is not a retrospective application, that this is an application for listed building consent to approve certain changes to the structure, the internal structure of the building. Would we have granted it? No. I defy anybody to think we would have granted removal of that staircase and the substitution of another one. So we're in some danger of not being consistent in our decision-making. We entertain a large number of planning applications for listed building consent, and we are rigorous in analysing them and in asking for the changes to be fully justified before we consent. We have not got that full justification in front of us here. If this had been made as a straightforward rather than a retrospective application, I am absolutely 100% sure we would have refused it. So we're in some danger of treating unauthorised activity better than authorised activity.
Just one moment. I've got Councillor Chris Cassabates, and I have seen your hand up online, Councillor Kirby Green. I just wanted to make a comment on that one, which is, A, it's hypothetical whether or not we would have said yes or no, but had there been justification for the staircase, we probably would have said yes. But the staircase has gone. I keep coming back to the fact the staircase has gone. Nothing we can do can get that staircase back into that location.
But that means, Chairman, that frankly, the next 5 houses that come from Burwash who have taken unauthorised action because they've seen this happen will actually, we are giving a licence to hooligans.
Right, one moment. I'm coming to a magic solution before I come to Councillor Creasy, who had a solution, Councillor Bayliss had a solution, Councillor Sting. I'm going to come to Gillian, who might have a
So
solution.
from everything that Councillor Barnes is saying, I'm getting to the proposal results in insufficient justification for the removal of historic fabric harmful to the character, appearance, whatever of the listed. That's the words. Architectural and historic interest of the listed building, and we will attach the relevant policies and reference to the NPPF. If that, does that encapsulate where you were going?
It encapsulates what I feel. I have in mind also what happened in Hellingly, where the domestic history of the building, the domestic history of the building is interesting in its own right to social historians, and we are prejudicing that social character, social history.
Well, I think that's inherent in listed building of social. Yeah, Councillor Kirby Green, I'm advised that as you're not a member of the committee, I can't allow you to speak again, even though you may have had the person.
I was usually allowed to sum up.
Perfect answer for us. I'm not allowed to. You've written that down, haven't you?
Somebody has. Yes.
Because I'm going to have to say it again in a moment.
Oh, right, okay.
For a vote on it. I'll come to, are you still seconded, Councillor Groner, on what was said there? Right.
Yes, I will. But,
Thank you. I still have Councillor Creaser and Councillor Bayliss who want to speak, and I think Councillor Stanger just wanted a comfort drink. Councillor Creaser.
We find ourselves in a very difficult situation, and it doesn't behove us to reward someone for behaving badly. But that's not going to, by not giving this planning permission or giving any, not planning, the listed building thing, it's not going to resolve the issues we are now faced with. True. And one of the things that we hear so frequently is to look at something that is reasonable. Now, obviously, these people have behaved unreasonably. There's no doubt about that in any of our minds, probably theirs as well at the moment. However, we can't get the staircase back. We can't get the doors back. If it's done reasonably and under a very strict regime, then we should proceed. We haven't got a lot of choice, because you can't just leave it. It will deteriorate very quickly. So rather than be happy about it, we could find some way in a planning, legally kind of way, to say we might not be happy with this, but we are stuck with a situation. Anybody else comes forward in future, and they're going to get their heads chopped off.
Right, I've got Councillor Bayliss, Councillor Byrne, and then I'm going to go to the vote, I think.
I'm really sympathetic to Councillor Barnes's perspective, but I agree with Councillor Creaser that we are we are where we are decision, I think. Is there any opportunity to preface our granting of the application to say reluctantly we agree this because of the
You can say it and have it in the minutes.
Could we have that in the minutes?
But not in the motion, I don't think.
Yeah, no, I think
it would be in the minutes, yes, if you wanted that in the minutes.
yes. I mean, I just sort of think if we were to grant it and we were to put that in there.
We'll come to that in a moment, because the first motion is to reject it, which we're going to vote on.
Yes.
So Councillor Byrne and then Councillor Ganley, and then we're going to go to the vote on rejection. Councillor Byrne.
So, Councillor Jason, sorry, could I just snip in? I'm the ward councillor, and I thought I was allowed to sum up before the vote. That's normally been the case with a ward councillor.
No, not to my
knowledge.
knowledge.
Councillor Vine Hall operated different rules to you. Okay, thank you.
Councillor Byrne.
Thank you. Just again to sort of summarise, if we reject this, we're not requiring those people to take any remedial action whatsoever. Right. We're saying you don't have to take the insulation down, you don't have to do this, you don't have to do that. And however, we are saying we might enforce later, but we know probably we don't have the resources or even, well, we just don't have the resources. So if we pass this, we immediately get 3 remedial actions taken with timescales. If we say no, then the building goes back to exactly the state it's in at the moment, with no way forward for the mitigation of anything that's been done.
Thank you. Councillor Ganley, you've got 10 seconds.
Paragraph 718, big page 74. In the middle of that paragraph, there is a phrase, materiality consistency. I don't know what that means. Could somebody tell me, please?
Michael, big page 74, paragraph 17, 118, right in the middle.
Materiality consistency.
It's just the consistency of materials along the rear terraces, so it's just what the majority of materials consists of. Is that consistent along the rear of that terrace?
Okay,
So that's same as Simon.
Might be no material consistency, should be.
Councillor Barnes, I will let you, as we're going to go to vote on your
Well, we're in
motion.
debate. We are the guardians of a public interest. We actually have to safeguard this statute. That is our statutory duty. If you give in to force majeure on this one, there are more than enough cowboys around this district who will make you in the same position next time, and the time after, and the time after. If you don't defend on the first breach, you will end up with breach after breach after breach. You may not want to listen to Cassandra, but Cassandra has spoken.
Yes, I'm now going to go to the vote. The motion is to reject the officer's recommendation and to refuse the listed builder consent on the basis that there is insufficient justification for the removal of the historical fabric harmful to the architectural and historic interest of the listed building.
And the policies, which will add.
And the policies which get added later. So all those in favour of rejecting the recommendation and refusing the application, please show. Nice and clearly, please. That's 3. Those against? That is, any abstentions? 1. That is lost. Councillor Stanger.
I'd like to move the motion to accept the officer's recommendation. We've got a second. Sorry? With the addition of reluctantly in the minutes.
Reluctantly is
Do I
in
have
the
a
minutes.
seconder?
So was that you second? Was that you seconding?
I was seconding that, but if
With
there's a
reluctantly.
better way of putting reluctantly, if there's a stronger word that we can put in, because I do think Councillor Barnes is right in that I do think so. Yeah.
Okay. Yeah. So the motion now is moved by Councillor Stanger, seconded by Councillor Bayliss, reluctantly, regretfully, and all the other words that mean that, to accept the officer's recommendation to allow the listed building consent. All those in favour, please show. Sorry, Councillor Bayliss, reluctantly. Those against, please. And abstaining, 1. That is, sorry, 2. Oh, sorry, you're sitting next to each other. 2. That is carried. Listed bill consent is granted. We will now break until 2:30. Thank you. We're resuming September's Planning Committee meeting with agenda item 12, application RR 2022-1388/DC. It's land at Clavering Walk, Bexhill, and the proposal we're discussing is a submission of details required by conditions 11, 16 and 17 imposed on outline planning permission RR 2018-3127P, and condition 2 imposed on approval of reserved matters RR 2020-2260P. This application is on the agenda because the Planning Committee, in determining the reserved matters submission in August 2021, requested that consideration of the details submitted in response to condition 17, the surface water drainage of the outline planning permission, be reported to the Planning Committee for its determination, along with a draft appropriate assessment under the Habitat regulations. The recommendation is that it be resolved to agree appropriate assessment and approve details reserved by conditions 11, 16 and 17 imposed on outline planning permission RR 2018-3127P and condition 2 imposed on approval of reserve matters RR 2020-2260P as detailed in the following documents. And they're the Construction Environmental Management Plan, dated the 8th of March 2024, the Construction Traffic Management Plan, dated 22 March 24, Drainage Technical Note, dated 25 of March 24, and the Drainage Maintenance and Management Plan, dated the 16th of June 20 something, because I didn't print it.
AABE. I know AA is appropriate assessment. But what's AABE? C, D, E, F? No, AABE.
No, I had a similar question. I assumed it was going to be for Bexhill, but
it's a typo, I think, on the committee report.
It is a typo.
Yeah.
Thank you.
It's a typo.
It's a typo.
Okay.
Good. Chairman, while we're clarifying, could I ask what PCW LMB is?
That's the Pevensey and Cutmill Water Level Management Board. And Revia Kinsella, who moves seats just to confuse me, is the area manager, and she'll be available for questions along with the officer when we get there. Right. This application, there's no public speaking on this one because this application relates to the discharge of conditions imposed when outline planning and then the reserve matters applications were granted. It is unusual for such technical issues to come back to the committee rather than for officers to decide upon. But the previous planning committees, when granting these permissions, specified that the appropriate assessment and the surface water drainage proposals should come back to the committee for approval. In these circumstances, the public speaking scheme does not apply, and therefore the planning officer, Edwin Cork, will present the report to the committee, and before being asked questions by the committee, Councillor Winter is here, one of the ward command councillors, who is allowed to address the meeting even though the public speaking system doesn't apply. Clear? Right, thank you, Mr. Cork.
Thank you, Chair, and good afternoon, councillors. This application for approval of details reserved by condition follows the grant of outline planning permission and subsequent approval of reserve matters for the erection of 70 dwellings. And if you can just move on, the application site here is outlined in red. If you go to the next slide, please. The application site is the two fields that you can see in the centre of the screen. The southern field is where the 70 dwellings would be, and the northern field is essentially where there's going to be open space and a suds treatment train. And the next slide will show the 70 dwellings just in context. The application specifically seeks the approval of details relating to conditions 11, Construction Environmental Management Plan, 16, foul water drainage, and 17, surface water drainage, imposed on the outline planning permission, and condition 2, which also relates to surface water drainage, imposed on the approval of reserve matters. These conditions were imposed in order to protect the nearby Pevensey Level Special Area of Conservation, Ramsar site, and site of special scientific interest, and to secure the satisfactory drainage of the site in the context of the adjacent Pevensey Levels, the general surroundings, and flood risk. The submitted condition details propose mitigations such as silt trap fencing for the construction phase of the development and a comprehensive drainage strategy which includes the provision of a suds treatment train for the operational phase of the development. If you just click on to the next slide, that gives you a kind of broad overview of the suds treatment train in the northern field, which is the 3 attenuation ponds and connecting swales. And in the southern part of the site where the housing is, it's just kind of a piped drainage network with an interception swale running along the southern boundary of the site. And towards the western end of the site, there is a 300mm earth bund, which is outlined in blue, which if you could just go up, please, Sarah. Just further to the up, yeah, it kind of snakes around there. That's a 300mm earth bund. This type of application, which requires the approval of technical details, would not normally come before the Planning Committee for determination. However, as the Chair said, when the Reserved Matters application was determined in August 2021, members requested that consideration of the details in response to Condition 17 of the Outline Planning Permission be reported to the Planning Committee for its determination, along with a draft appropriate assessment under the Conservation of Habitats and Species Regulations. Members will note that the application includes details relating to other conditions which do not need to be considered by the Planning Committee, but they are included because they form part of the applicant's submission. The technical nature of the application means that the Council relies on technical consultees to advise on the acceptability of the condition details. In this case, the details have been reviewed by the Pevensey and Cuckmere Water Level Management Boards and the Lead Local Flood Authority, the Environment Agency, Southern Water, the County Ecologist and Rovers Environmental Health Service. Barag Local Action Group have also reviewed the details and made representations. The technical consultees have advised that they have no objection to the proposed mitigation measures for the construction and operational phases of the development, as detailed in the latest versions of the Construction Environment Management Plan, Construction Traffic Management Plan, Drainage Technical Note and Drainage Maintenance and Management Plan, and also having regard to the representations from BOAG. Turning to the appropriate assessment, Rother District Council, as a competent authority, must undertake this in relation to potential impacts on the integrity of the Pevensey Level Special Area of Conservation and Ramsar site. If this is passed, then the Council can decide to approve the details reserved by condition. A draft appropriate assessment has been carried out based on the mitigation measures outlined in the condition details and having regard to the comments received from the technical consultees and BOAG Local Action Group. This concludes that officers of Rother District Council are satisfied beyond reasonable scientific doubt that the development will not have any adverse effect on the integrity of the Special Area Conservation and Ramsar site, either alone or in combination with other plans or projects. Natural England, as the appropriate nature conservation body, have advised that they concur with the assessment conclusions, providing that all the proposed mitigation measures are secured. These measures will also ensure that the development will not damage or destroy the interest features for which the Pevensey Levels Site of Special Scientific Interest has been notified. In light of the positive response from Natural England and objections from the technical consultees, it is recommended that the appropriate assessment is agreed and the submitted condition details are approved. Thank you.
Thank you. Before we move to questions, Councillor Winter, please, the Ward Councillor.
Thank you very much, Chair. Firstly, by way of context, these proposals are for a highly sensitive site, which lies directly adjacent to the Ramsar, SSI and SAC designated Pevensey levels, one of the most important wetland areas in the country. Any change to water quantity or quality are a threat to the levels and put an already unfavourable environment at an even greater risk. It is important to understand that what is proposed for the Clavering development is not and cannot be a filtration drainage scheme. Because of the risk to the Pevensey levels, surface water must be held and treated before it enters the levels. Polluted surface water cannot be allowed to enter the ground untreated. I ask you to hold this thought during the discussion. Special areas of conservation and Ramsar sites are protected sites under the Habitat Regulations, Regulation 63, requires competent authorities to undertake an integrity test, only agreeing to the proposal after having ascertained that it will not adversely affect the integrity of the site in perpetuity. You are asked today to make a Habitat Regulations appropriate assessment under Regulation 63. It is this legislation alone which determines if an assessment can be passed. It is only if the assessment is passed that you will then decide if conditions 11, 16 and 17 and associated condition 2 can be discharged under the Town and Country Planning Act of 1990. It is entirely feasible for you to determine that planning conditions have been met under planning law, whilst at the same time finding that particularly high bar of Regulation 63 of the Habitat Regulations has not been met. Secondly, the key legal position relating to decisions under the Habitat Regulations relates to 5 key messages that I would like to draw your attention to. Number 1, the assessment must be particularly robust to the highest standards of investigation. Number 2, the assessment can have no gaps and must contain complete, precise and definitive conclusions and be based on the best up-to-date scientific knowledge. 3. Applying the precautionary approach, mitigation can only be considered as part of the appropriate assessment when it is sufficiently certain that the proposed measures will be effective in avoiding harm for the lifetime of the development. 4. There must be no reasonable scientific doubt that it will not affect the integrity of the site. This doubt must be ruled out at the date of the decision authorising the project, not based on something that might happen or should happen later on. And number 5, relevant considerations will include not only what, but crucially how mitigation measures will be implemented and monitored, and how any enforcement will take place. It is against these exceptionally stringent requirements that I put to you the case that the particularly high bar has not been met and the appropriate assessment before you cannot be passed. Some further areas of concerns that I would like to raise to you include number 1, uncontrolled and unfiltered exceedance leaving scientific doubt about impact on the Pevensey levels. Number 2, the failure to deliver a precautionary approach by using an out-of-date climate change allowance of 40% when the government guidance is now 45%, plus a failure to adequately allow for extreme weather events. Number 3, the best up-to-date science has not been demonstrated by Southern Water's failure to assess the capacity or durability of the system expected to have sewerage from 70 new houses added to it. There is no evidence that proves an adequate capacity now or in the future. 4, the appropriate assessment is incomplete and has a gap regarding the unmitigated risk of badger damage to the suds banks and liners, resulting in an untreated water reaching the levels. The appropriate assessment is imprecise and does not have a definitive conclusion. The risk is real and no mitigations have been offered. And 5, mitigation can only be considered where it is sufficiently certain it will be effective for the lifetime of the development. The outlined long-term management of the drainage systems does not meet this criteria. So, Chair, to conclude, as Rother is the competent authority, we have the responsibility to assure ourselves that this appropriate assessment is robust and has achieved the legally required high standard of investigation, meeting the particularly high bar set by legislation and reinforced by English case law. It is my case that significant doubt remains in relation to the risks posed by pollution, such that the legal thresholds have not been met. I urge, therefore, that you find that this appropriate assessment is not passed and conditions 11, 16 and 17 cannot be discharged. Thank you, and this speech was read on behalf of the Bearway Opposition Action Group.
Thank you, Councillor Winter. Can you just clarify what group? BOAG. BOAG. Thank you. BOAG. I know. Right, question. Yeah, I will make the observation that ward councillors and councillors addressing the committee shouldn't actually be reading on behalf of other people. It is for their own personal comments. But it's been said, it's been done, so I can't put the genie back in the bottle. So it's now question time of members for the officer, please. And sorry. No, I'm sorry. No, there's no public speaking. Do you know what no public speaking means? No. Thank you. And he's not supposed to. He's supposed to say his own version. But I'm not going to enter a discussion with you. There is no public speaking in this. Thank you. Yeah. Sorry. Who are you from? Sorry. Are you the applicant? Right, sorry, I know what you mean. I know the point you've made.
We'll have a conversation.
We'll have a conversation. To members, the problem is that BOAG specifically were not allowed to come and address today because there was no public speaking, and Councillor Winter has delivered their speech for them, and the applicant has not had an opportunity to speak in favour of the application. That's the problem we're struggling with. Councillor Baines.
Could I make a suggestion that we allow the applicant to address the committee?
We'll discuss it. I don't think so. Right. Councillor Bayes, I know it's a lovely common sense approach, but since when did common sense and councils come into play? So what's your name, sir? Sorry. Mr. Goodban. Yeah, thank you. Right, Mr. Goodban, because of what happened, I'm going to ask you, are you willing now, bearing in mind you've not had time to prepare, to speak to the committee for 5 minutes? If not, I will have to defer the matter.
Still should be no public speaking next time because it was not.
Yeah. And of course, there will be no public speaking next time.
The problem is we can't make a balanced decision.
No.
I could not speak to him.
The head of the interim, let's, can we, no, because we've started, no. The head of,
Just adjourn sitting here, don't move.
right, we adjourn the discussion, but stay put. The head of planning will come and speak to you, Mr. Goodban. No, no, it's not a public meeting. Sit down, please.
Just for clarification, the difficulty we have is the ward councillor read a script that wasn't prepared by him, that was prepared on behalf of yourselves.
Correction.
No public, can you let me finish, please?
No, it's me.
There's no public speaking rights.
Okay, it was prepared by me.
So the applicant didn't have the opportunity to respond. In the interest of natural justice, it is only right that we give the opportunity to respond, because the ward councillor has bypassed the public speaking rights on this occasion. So that's what we're discussing at the moment.
Right, members. Sorry, it's Mr. Goodband, isn't it? Yes, sorry. Mr. Goodband has agreed to address the committee for 5 minutes to make up for what we've heard. However, and I will allow it, because he's unprepared, if you have a technical question for one of the people with him, I'll let them answer the question rather than him, because he didn't come prepared for speaking and questions. So it's up to you not to ask too many difficult questions. So, Mr. Broadbent, if you could come forward, please. Thank you. Introduce yourself, and you have 5 minutes. Thank you. So just before you start, if there are any further interruptions from the public gallery, I will be clearing it. Thank you. So, yeah.
Good afternoon, Chair. Apologies for the comments, and thank you for letting me address you this afternoon. As mentioned, I'm slightly unprepared in relation to comments, but in terms of the proposal, we are seeking here is what should be a simple discharge of planning condition. The Outline Planning Permission has been granted and was approved in February 2020. The reserved matters was then approved in August 2021. I personally cover planning issues across the south east of England, and in no other authority have we experienced such delay to such an extent when dealing with planning conditions. That said, we are before you today, and hopefully we'll be able to resolve this issue and be able to start on site shortly. Over the course of probably more than 3 years, we've demonstrated to an unprecedented level, I would suggest, a level of detail, response, workings, to be able to develop a robust and thorough justified proposals. These have addressed all issues in regarding to drainage, sustainable urban drainage systems, and any potential impacts on the Pevensey levels. And we've been meticulous about this, and we've considered and responded to all of these comments, and we've submitted and all of the comments that have also been submitted and provided by BOAG. It's therefore clear to me, and there is evidence, that there is no stone unturned. There are no questions that remain unanswered, and there are no what-if scenarios left understood. We have comprehensively and robustly dealt with every issue, every question, and every query that has been put in front of us. And this comes to a point whereby all the technical consultees are now satisfied with the scheme, and that we are compliant with all necessary regulations. So, what do you need to know? We need to know whether you've got any objections from statutory consultees. We haven't. That includes the Environment Agency, the local flood authority, and Natural England. Natural England are the key people in relation to the appropriate assessment. They, somewhat bizarrely, because they don't normally comment on planning applications, have commented on this application, and they've said that they find what the appropriate assessment conducted by your council officers to be acceptable. I'd leave you really with paragraph 1.4, which is in your report, and that states that your officer's conclusion is that RDC is satisfied beyond reasonable doubt that the development will not have any adverse effects on the integrity of the European sites, either alone or in combination with any other plans or projects. It's therefore clear to me that this application should have your full support, and I urge you again to approve this application. Thank you again, Chair, for this sort of guest appearance, shall we say. And if you have any questions, then I am joined by various members of the team as suggested, and we can, I'm sure, answer any questions you've hopefully posed.
Yes, I put in that caveat. Thank you, Mr Goodman. Councillor Ganley.
Thank you, Chairman. I just wanted to say thank you for your presentation, and I'm sorry that you had all this hassle. It should not have happened. Why we asked for this to come back to the planning committee is beyond me. I'm sorry it's happened.
Thank you very
It was
much.
for questions, but I doubt if Mr Goodman understands why it came back to committee either. Any questions for Mr Goodman, please? Councillor Mary Barnes.
Yes, thank you. Hello. How long will whatever drainage system you put in, how long will it last?
It will last for the lifetime of the development. We will be putting in place a management programme and a management plan, and it will be managed by them. So if anything has to be replaced, it will also be monitored by them. So if anything needs to be replaced, anything needs to be upgraded, it will.
Are we talking about 50 years, 80 years, 100 years? How long?
For in perpetuity.
In perpetuity. And during that time, I was just looking at 325 of the, I think it's the conditions at the end, and I was looking at this last night, looking at the number of people who would be stakeholders, who would be responsible for the maintenance and management of, they're talking about on-site foul water drainage. So you have Icosa Water, East Sussex County Council, the Private Management Committee, and then quixotically, individual property owners responsible for the operation and maintenance of privately owned components of the surface water system within the curtilage of their property. This doesn't sound to me like a 100% totally watertight, satisfactory way of coping with what should be a completely fail-safe operation.
I may refer to, I may ask another colleague to comment on this, but Icosa is a independent management company operated under the Ofwat, is that correct, regime. So essentially what we're doing is we're handing over a system, and we're handing it over to a national operator to run and operate it. I think, does that help you?
It is, but we learned a little bit about appropriate assessment some years ago when we were looking at the Spindlewood site. And from that we understand that an appropriate assessment must be complete in all its parts. There should be no gaps. It should be 100% reliable. And at the time, it fell flat on its face because that condition could not possibly be met. Now, it may be that we've suddenly found that modern science has moved on, but I have still to be persuaded. Could you possibly do something?
I can't really comment on the Spindlewood Drive, but...
No, it had to have an appropriate assessment, because one of the things that was said, and is absolutely sure, is that this is a very sensitive site. But I think in the end you're answerable to the European courts, aren't you, for this thing working properly? And in the end, it would be rather District Council who would be paying the fine if the thing goes wrong. That's what we were told last time. Now, is that right?
I'm going to look over my left shoulder. Apologies.
It's funny, I'm looking over my right shoulder.
Yeah, we're handing it over to do you want to go with? Thank you, Councillor. Apologies for the delay. I mean, in terms of the SUD system, the entire system would be operated by Icosa Water. So at that point in time, then if there were any breaches, etc., then it would be similar to breaches to any other water authority. So you would be able to go through the essentially the normal routes. Now, I appreciate that Southern Water don't have the best of representatives.
I was just going to say that was a really bad example.
I know, the mitigation and the measures are all in place to allow that to happen. And in fact, what you've got here through the Section 106 agreement, you've got the ability for the council to enforce the developer and through ICOSA Water. So you have the ability, a hook to go not only to ICOSA Southern Water, but you also have the ability to go through the Section 106 mechanism should any enforcement need to happen. Does that?
Yes, but to a certain extent, yes. But it's no use quoting any other development. We're talking about this development, your development, and we are giving you permission, you hope, for this particular drainage system. So the onus is on us to have confidence that you're going to get it right. But I think at the end of the day, it's a very, very big ask of us, because I still think that it's 50 years down the line, who's going to be still interested enough to keep this going? We're talking about inspections, annual inspections by Rother District Council. Who from Rother District Council is going to know how to do this properly? They're also, I don't have any real confidence that at the end of the day this is actually going to work. So, I just don't get it.
Okay, it wasn't a question.
Well, I think if I would rely on your statutory consultees. The consultees that you have assessed the application have gone through a thorough and robust assessment of what's being proposed. So they've looked at it not only in relation to the drawings of how it's going to be completed, what's being proposed, the materials being used, the management regime, the maintenance regime that goes informs that. They have thoroughly assessed that proposal. So sorry to say, but you don't have to. I would rely on that and have a great deal of confidence in that in making your decision.
Thank you. I'm not going to suddenly ask you. Have you anything to add? You probably haven't.
Thank you, Chair. I think what I would say is we being the Peffens and Cookmere Water Level Management Board and the lead local flood authority, because we work as a partnership when sites affect the levels. We have spent a number of years working with the developer, trying to get to a reasonable solution. And because also for us as a Water Level Management Board, we do manage the levels. So anything that comes to the levels, it affects how we manage them. We manage the water levels around there. So we as an organization also have a vested interest in making sure that anything that is done does not impact us negatively in the work that we do. So in the assessments that we have done, looking at the application, the design as it stands did go a long way in terms of introducing appropriate treatment stages. Usually for the Peffens levels, I think it was in the Rother District Council's DASA, which says 3 treatment stages. But when we were working with the developer on this one, we asked them to do their design in such a way that the water can pass through. It is passing through 5 stages. So you have the first pond, then you have the swell, which then those two do the treatment. Then you have the second pond that also introduces a level of treatment. Then you have the third pond that introduces a level of treatment. Then before it goes into the core stream, it's going through a swell, which introduces the 5th stage of treatment. So in terms of treatment, we have worked with them to make sure that there is enough treatment stages within the system to mitigate against the impact or on the Pevensey levels. And in terms of pollution, the pollution usually happens when rain falls on dry ground. So the first 5 millimeters of rain, when there has not been raining and there have been petrol leaks and everything on the ground, that's when the first flash of rain, when everything is empty, that is what can causes the most harm in terms of pollution. But it is at that point, when the first 5 millimeters of rain, the system is most likely to be empty because it has been dry. So that water will stay within the system. And as the system is maintained, they say the silt is removed throughout the maintenance stages, then it means when you have the exceedance events, that water is usually quite diluted. There is a minimal amount of pollution that will go into the levels. So it's usually, when we're talking of pollution, we worry less about the exceedance events, but we worry more about the small rainfall events to make sure that they don't go into our waterways untreated.
Thank you.
Thank you, Chair.
So I was apologising for putting you on the spot. I'm glad I asked you because that was so informative. Thank you very much. Thank you. I'm glad I asked you. What a good idea that was. Are there any more questions of Mr. Good? No, because I realise I shouldn't have done that because Mr. Goodman's still sitting there. Are there any more questions of Mr. Goodman before we come to the officers? Councillor Ganley, then Councillor Gray. Sorry, Groner. TG.
TG. Is there, sort of following on from our friends here?
No, this is for Mr. Goodman before I let him go.
Following on from that, is there a secondary line of defence? I mean, it sounds like the treatment and 5 tanks is pretty robust, but is there a secondary sort of line of defence to prevent water entering into the levels?
Because Revi kindly said that normally you'd anticipate, was it 3, and then we're proposing 5.
Right.
So you've got a secondary and then a thirdly, a tertiary. Yeah,
but that's
thank you.
Within one system. Is there a secondary system beyond that treatment that somehow sits in between?
No, because I think we're talking here about the surface water. So it goes into these sort of 5 catchment areas: first pool, second pool, third, fifth pool, and before it gets back into the stream.
Yeah.
So.
Okay.
So essentially, the water that comes out of the sky lands on the roofs or into a garden, percolates. By the time it's got there.
No, I think that's fine.
Okay, fine. Thank you. I'm going into hydrology.
Thank you, Mr. Goodman. Councillor Gray.
Thank you, Mr. Goodman. You said there were no unanswered questions, but for me, the biggest question is the impact of climate change, and I just wonder how far you've looked ahead. We know there's going to be increasing storms, heavier and heavier rainfall. Those of us that live in Bexhill are terribly aware that I've lost count of the number of sewage spills we've had in the sea. As recently as last weekend, a triathlon had to be cancelled because the sea was too polluted after very little rainfall. Lots of us have no confidence at all in the sewage system. How can you answer that? Not just looking at now, but looking at the future. And could I just say that it would just take one spill of sewage into the precious Pevensey levels to totally destroy that habitat? We have the huge weight of responsibility. This is a Ramsar site. It's internationally renowned and listed. The responsibility for that weighs very heavily upon us.
Fully understand those comments, Councillor, and you're right, and clearly you're right to be concerned about climate change and right to be concerned about impacts in relation to pollution within waterways, etc. But in terms of it was mentioned earlier in relation to climate change for this development, we have a condition that talks about 1 in 100 years plus 40%. But I believe I'm right in saying that we've done some sensitivity checks and we are at the level of 1 in 100 year event plus 5% climate change. And that is kind of considered to be a suitable level or a suitable bar or surplus above and beyond what we're essentially required to do. I can't answer your question in relation to climate change, etc. But hopefully that's some way to answer it.
Thank you, Mr. Goodman. That was. Have you brought your crystal ball with you? Yeah. Of Mr. Goodman. Okay. Councillor Mary Barnes.
Have you built a model of what your pumping system would be? Because I believe that is a requirement of the appropriate assessment.
We built essentially a computer program model, but we don't have a physical model, if that's where you're at. So we have a quite a sophisticated, quite complex hydrological model of how the drainage will work and operate. If I'm right in saying that.
That's correct, yes.
This guy here is the guy who's done it. So
provided detailed calculations to the lead local flood authority who have reviewed those calculations.
So it was a computer model, not an actual model, like we had of Sidley last time. Councillor Mr. Barnes.
Yes, so the last interchange interested me. Have you tested the point at which that model actually goes wrong? In other words, we're satisfied you can deal with a 45-year event. We're satisfied you can deal with 1 in 100. Have you actually run the model to see where the break point might actually come?
I'm going to have to look over my left shoulder on the basis that I've never seen the model. I've no idea how it works. I've seen a printer. I've only ever seen a result. Sorry, Ed.
So we've run the model for the 1 in 100 year plus 40%.
Could you come forward to the microphone? Sorry, we've got
Sorry.
the recording, so it makes it.
So we've run the model for the 1 in 100 year plus 40% climate change and 45% climate change as required from the planning policy. There's no requirement for us to run any further events like you've suggested.
Yeah. Okay. Yeah. So the answer is no.
No.
Yeah. That's all right.
Thank you.
As per kind of the planning policy, we've run the correct storms.
Right. Are there any more questions from Mr. Goodman? Because we haven't started questions of the officers yet. Of the officer, Councillor Groner.
Yeah, just in terms of the modelling, has there been actual readings taken of the waterfall, surface waterfall, next to the models? Because in terms of, just to explain, Southern Water have a Pathfinder project that we're involved in down in Fairlight and Pett, and we've got lots of surface water flooding issues. And we found that a lot of their modelling isn't necessarily, they've learnt a lot by taking real data and putting it next to their models, and their new mantra is measure, don't model. So I was just wondering if you've done physical tests to support.
So we input local rainfall data into the model, so you purchase that data and that is based on local readings and local measurements. So that's the FEH data that we used.
Thank you. I'm not detecting any more questions, so thank you to Mr. Goodman and his able assistants at short notice. We now have questions of the officer. Does any member want to ask questions of the officer, please? Right. Oh, Councillor John Barnes.
Yes, I think there is one point which I think the officers might be able to help for, but possibly it may be a more technical thing. But we're dealing with a multiplicity of agencies that are going to be responsible for this system over the next 50 years. The pump house seems to me the real sticking point where they might actually get an event which isn't under COSA. This is under Southern, or is it under the Drainage Board? And I'm just wondering how far that has been looked at and mitigated.
If I understand correctly, you're referring to the Southern Water Pump House, which isn't actually on the site and doesn't form part of the proposal. That is an off-site pump house that serves existing properties in Clavering Walk.
Thank you. And now, is it a question for the officer, or are we going to? Okay, I was just going to begin discussions. That was all. Keep facing forward. He won't think you're rude speaking into the microphone.
Thank you, Chairman. To the officer, are you content that what needed to be done has been done?
Yes, Councillor. We've been through sort of 2 years of negotiations and getting updated documents to satisfy all the technical consultees. And moreover, Natural England have looked at the appropriate assessment, and as the appropriate nature conservation body have agreed with our appropriate assessment. So yes is the answer.
Thank you. Well, not unless you've got something else to say, Councillor Ganley. It's open for discussion now. And anything else that comes to mind, Councillor Ganley? Councillor Barnes.
I'll get us started. As one of the members who took part in the original discussion on the Planning Committee, the problem here is the appropriate assessment. It's not what Bellway are doing. I think they've been exemplary in their efforts to meet planning conditions. But we have to satisfy ourselves under the terms of the appropriate assessment that these arrangements are durable in perpetuity. That's a very stiff test. I didn't set it. The law sets it. One of our worries at that stage was a lot of this was going to fall on a private management company, and I think we have made considerable progress because a specialist company is now going to undertake a large part of the work. The trouble, of course, with a company that's in the private sector is they can go bankrupt, they can go out of operation, whereas public bodies like drainage boards, Rother District Council, county, statutory undertakings can't be abolished without somebody putting something in their place. So we do need to be very satisfied, and this is where I think the officers may want to comment on what happens if it goes under. We have the right to nominate, I think, another company ourselves, but I'm not sure we have the knowledge in Rother to do this. One of the things we welcomed last time was the involvement of the Drainage Board, because they would have substantial knowledge and have a very direct interest in making sure these arrangements were robust over the medium to long term. I'm not worried about the short term. It's the medium to long term, particularly since climate change is going to prove pretty unpredictable, I suspect. So the reason it's coming back to committee is because of the appropriate assessment, not because normally you wouldn't bring planning conditions back. But the appropriate assessment, if in fact it's breached, if in fact we are fined, we are liable, rather. It's an unusual situation, but we are the guardians of the Ramsar, which is a protected land just like the AONB, and we are the statutory body responsible for protecting that. The other weak area in this, and I don't want to be too libelous or slanderous, I think, in this instance, but Southern Water's track record has not been great. And they are a rather substantial part. I would have been much happier if Southern were not involved at all, but of course, all these responsibilities are part of our rather fragmented statutory structure, where different bodies are responsible for different bits. I personally think that the bits under ACOSA look extremely robust. I'm less sure about some of the other bits, and that's really what I would welcome some comment as we go through the debate from officers about how we have protected ourselves against future harm to this authority, because the fine can be very substantial.
Just before, if Ed's going to say something, can I just remind you not to use Anglo-Saxon language. Thank you. Well, just before he said we're liable, he said something else. Moving on, Councillor Gray.
I just wanted to add to what Councillor Barnes has said. It's not just the damage to this authority, much more importantly, it's the damage to the Pevensey levels.
I mean, I'll start off. The application was, as you know, was first considered at outline stage and then again at reserved matters stage. And at both stages, we had appropriate assessments carried out. And the drainage scheme sort of before us now follows the principles of the drainage scheme agreed at outline and reserved matters stage. The scheme that we've got before us now has been reviewed by the Pevensey Levels Management Board and the lead local flood authority. And as Revo pointed out earlier, it's in their interest to ensure that the drainage scheme is acceptable, including the maintenance of the drainage scheme, so that it doesn't have any adverse effects on the levels.
Thank you. Any other comments? Sorry. Councillor Byrne and Councillor Stanger.
Thank you, Chair. This is really a question for officers. This is not the only development that borders the Pevensey Levels, and it would appear that this development is probably far better designed and takes more notice of the environmental considerations than ones that have been done a while ago. Yeah. So I think we're taking all possible care, especially taking into account the fact that we're trying to make sure it's future-proof. Mm-hmm. So, as I say, we are not the only potential contributor to pollution in the Pevensey Levels, and we are doing all we can, I think have done all we can, and therefore I would say that if this goes ahead, it's going to be one of the better developments on the edge of the levels. So that's all I want to say.
Thank you, Councillor Brown. Councillor Stanger.
Regarding if in hypothetical that the development went ahead, how is the enforcement then of ACOSA? Because I know they manage another site within my ward, which has already been built, and it's not very well managed. So how is that enforcement managed?
It's the enforcement of who looks out, who polices ICOSA, basically.
Yeah, because they manage Rosewood Park. Yeah.
ICOSA are just like Southern Water. So it's just it's so Ofwat are the ones that regulate ICOSA. So if ICOSA fails, Ofwat will be the one that chooses the next water company that will come on and take on the responsibility. So ICOSA is better than a normal management company because there is Ofwat who can step in and provide an alternative arrangement. If you think of it like when the energy companies failed, Ofgem decided who looked after the residents. So that will be the same in this case on the systems that ICOSA would take on.
Thank you.
Can I also just add something? I mean, we're all hearing now in the news where the government now are tightening up on this, so there's going to be new legislations even tighter than the current one. So you should feel confident in that coming forward. Thank you, Chairman.
Thank you, Councillor Cronin.
So I'm assuming that all the infrastructure in there is new. It's brand new, isn't it? So it's going to have at least a 50-year lifespan. Most of the Southern Water problems are because pipes have not been replaced since the 1880s or something, you know, whenever they first went in. So that's one assurance. But the only other thing is, how often is the water tested in the levels and by whom? I think that might have been mentioned, but sorry if it slipped my...
The EEA, usually, they do some water quality monitoring. They used to do a lot in years past, but now because that team is reduced, there used to be 15 people, there are now only 2 people in that team, but they do try to do some water quality monitoring throughout the levels.
So it's sort of annual, do you think, or biannual?
If there is an issue raised at a place, they could go sometimes every quarter. But if they don't know of any issues, it could be annual, or sometimes
But
less
finding
frequent.
the issues is by testing all the time. If they're the front line of defence and they're testing constantly, then they'll be aware of issues.
Yes, but unfortunately, because of lack of resources, now most of the reliance is on reporting of incidents, but they do monitor throughout the levels as much as they can.
Yeah, the story of public service is in Great Britain. I'm not detecting any more comments, but I'm also not detecting any motion moving, so I'm going to move that we accept the officer's report. Let me finish. Accept the officer's recommendation and resolve to agree the appropriate assessment, approve the details as laid out in the beginning. Seconded by Councillor Ganley. All those in favour, please. Nine. Thank you. Those against? 3. Abstentions? That is carried. That is agreed and the conditions approved. There is no agenda item 13, which is the performance report. That will be tabled at October's meeting. Agenda item 14, for members to note that the date and time for the next site inspection is Tuesday the 8th of October, departing the Town Hall at 9:30. And the next committee meeting is on Thursday the 10th of October at 9:30 a.m. That brings us to the end of this month's planning committee. Thank you and goodbye.